Have a seat.
My lord, may I mention?
Yeah.
My lord, I have filed 3 IA, which is for direction to the insurance company to deposit the 50% from the awarded amount.
Okay.
As 3, that may be listed on 13, my lord. 1311.
Okay.
Okay. There is another MSc appeal which is pending for admission. That may be listed.
List that next week. on
That 3 IA may be listed on 13.
13th. And MSc appeal, you can list it on, say, 18th. Right?
18.
Is it okay for you?
That may not be recorded after 3 weeks.
After 3 weeks?
Yes.
My please, Lordship. Lordship, I beg to mention one criminal petition number 90 of 25, which is pending before this honorable court. So may I have read that, Lordship, matter maybe I'm mentioning for withdrawal. So Lordship may take up it at 2 p.m. for withdrawal only.
Okay. Which one? Item number?
Lordship, not listed today.
Not listed.
So I'm making mention, Lordship.
Okay. You want to withdraw it?
Yes,
Okay.
at 2. Okay.
May I please, madam? In item number 22, 23, and 24, this is a criminal appeal against conviction. And in this case, my lord, all the process has been complied with. This matter can be listed for admission yet, though it not been admitted yet.
It has not been.
Not been admitted.
The processes are
Completed.
22, 23, 24. When the learned counsel submits for the appellant side, submits that the processes are completed in the case and the matter is ready for admission. Accordingly, list on for admission. Which date should
After 4 weeks.
after
4.
okay, after 3 weeks.
3 weeks.
My lordship,
Great.
my lordship, I beg to mention item number 4. On behalf of tea time, leading counsel is out of station due to medical problems.
Learned counsel for the petitioner side submits that the leading counsel, Mr. Tying,
Yes, lordship.
is out of station and seeks an adjournment, which is allowed. List after next week.
2 weeks.
After
You, that may be given, but otherwise there has been already a compromise between the parties.
I said that's
But
okay.
Mr. Tang is supposed to
No problem.
produce the records.
Can we fix it on 20?
Yes.
Fix it on 2020.
Obliged.
My lord, I beg to mention item number 35, my lord. My lord, with the consent of the other party, my lord, for a convenient, my lord, can this matter be released after 3 weeks, my lord? SLPP, my lord, will be conducting the case. He's not available today, my lord.
Your father?
For petitioner, my lord.
The petitioner counsel, learned counsel for the petitioner submits that with the consent of the other side is seeking an adjournment as the special PP is not available today.
My lord.
State PP not available today. The prayer is allowed. List after 3 weeks.
My lord. My lord, interim order pass earlier.
The interim order, right order dated so and so stands extended till the next date of listing.
Your lordship, I beg to mention on unlisted anticipatory bail application.
For today?
Yes, your lordship.
No.
Lordship, I beg to mention item number 17.
17?
Yes.
17. Yeah.
2 weeks time may be granted to reply the affidavit.
You're for the petitioner, appellant.
Appellant.
You're for the appellant side. Anyone appearing for the other side? You are
I
appearing
am.
for the other side? Okay. He wants some time to
Yes,
file.
ma'am. 2 weeks.
2 weeks time. Learning your good name, please.
Yes, Your Honor.
Learned counsel, as you are appearing for the appellant side. 2 weeks time to file a reply to the, your file affidavit.
Yes,
Affidavit filed by the respondent side. Prayer is allowed. List the matter after 2 weeks.
My lord, I beg to mention item number 36, my lord.
30.
It was 36, my lord. It was listed on Friday as well, my lord, last Friday, and then due to paucity of time, it could not be taken up.
I see.
My humble prayer that it may be taken up at 2, my lord.
Today?
Yes, my lord.
At the moment, let us keep it flexible. Let's see how the list progresses.
Okay.
It may reach in the normal course also. If not, we'll see what can be done.
Much love.
May I please, Lordship. Lordship, I beg to mention item number 6, 7, and 8, Lordship. Here, Mr. Conducting Counsel Digos is not come due to personal difficulty. He is from West Bengal, Your Honor.
West Bengal, D Ghosh.
Yes, D Ghosh. Conducting council.
Your good name, please?
G Tai Lordship.
G.
G Tai, girl.
Taye, G. Taye, learned counsel appearing on behalf of the petitioner, 7, 8, and 9, huh? 7, 8, 9. You are appearing same counsel.
Petitioner, yes.
The submits that the leading counsel, D. Ghosh, who's from West Bengal, has some personal difficulty today and seeks an adjournment for today. How, after when should I fix it?
2 weeks, Lordship.
Lays the matter after 3 weeks.
Deeply obliged. There is interim order now.
Interim order granted by order dated, just check it, stands extended, shall stand extended in the next date of listing. Okay,
Deeply obliged.
Lordship, I beg to mention item number 18 on behalf of T Taba petitioner. Lordship, I have been conveyed that the learned PP could not be able to present, so the matter may kindly be adjourned.
learned PP.
Yes, PP in the matter.
Okay,
And
Oh.
also Lordship, upon looking at the
no,
record,
prosecution has some difficulty. Okay, no problem. Yeah.
Lordship, upon looking at the record, I found that the service report has not yet been received. So
Oh, I see.
we pray for further time to take re-service.
Oh, can I have the files? Your good name?
A Gamre, on behalf of B Taba.
Appearing on behalf of T Taba, leading counsel, submits that. That the matter may be adjourned today as the learned PP is stated to be not available. It's said to be not available. Full stop. It is also submitted that service upon respond number 2,
Yes.
not yet completed. And the petitioner side undertakes to take fresh service. Fresh service accordingly may be taken. You want to take it by registered post?
Yes.
By registered post. Full stop. Is the matter on?
Lordship,
When should I fix it? After?
after 3 weeks. Lord.
After 3 weeks.
And there's an standing interim order.
Okay. Interim order dated ... extends to the next date of listing. Place the matter after 3 weeks.
And Lordship, I beg to also mention item number 19 along with 20. The counsel for the petitioner is an outstation advocate, and as such he prays for 4 weeks time for this next day.
Have you?
I've taken consent from the other.
Same, learned counsel appearing for the one case is appeal and one case is revision. So you write appeal, appellant, other case, revision, petition. Submits that N. Sharma, the leading counsel, and N. Sharma, the leading counsel, is an outstation counsel, and he has some personal difficulty and seeks an adjournment the day. The council also submits that he has taken consent of the other side. This is the matter after. Any
4 weeks, Lordship.
after, you want the specific date? He's coming from where?
From Assam.
Assam. Got it.
Yes.
So this is the matter after 4 weeks. If you want a date, we can give a date also.
After 4 weeks.
After 4 weeks.
If I may, Lordship, also item number 29.
So many.
In item number 29 also, the report is still awaited. We have taken the survey, but the report is not yet come. So also in this matter, we further beg some more time to reach that.
Respond number 2 or
Yes, sole response.
sole respondent. 29. It is submitted that service upon the sole respondent is not yet completed and still awaited. Full stop. We shall await or fresh steps will take. The same may be await.
Yes, we can also await
And this is the matter after 3 weeks.
3 weeks. And there's an interim order. Of course,
Kindly look into the steps. Otherwise, since there is an interim order, kindly take the step. The interim order granted by the order dated. The order dated 7/8/2025 stands extended till the next date of listing.
item number 1
May I please, my lord, by way of this application, my lord, the petitioner is seeking some protection from this honorable court against an FIR which is under inquiry before the Women Police Station, Itanagar,
Mhm.
and the same has not been registered yet. I'll show from the record my genuine apprehension, not only fear.
There's no FIR.
No FIR has been registered yet. My lord, the gist and my lord, the background of the case is that I was in a relationship with a lady for around 6 years.
Mhm.
I provided all the financial assistance, in fact, more than which was required.
Mhm.
However, since last few months, I had some difficulties, some differences with the lady, my lord.
Mhm.
And we have tried to resolve the matter, but could not resolve it. And accordingly, I have filed an FIR against her. If my lord may kindly have page number 19.
She has filed an FIR.
I have filed an FIR against her.
Oh, you have
Against her, I'm sorry. Page number 19, madam.
19.
Basically, my lord, the FIR was for cheating, fraud, and stealing my vehicle, my lord. And subsequently, my lord, on 8/10/2025.
This was registered. as a case.
Registered, my lord. Registered under section 316(2), 318(2), and 319 of the BNS for cheating, my lord.
Then
And
what happened?
Subsequently, she was arrested on
She was arrested also.
8.
What is the date of this FIR?
7/10/2025.
Then what is the 710?
Yes, my lord.
This FIR.
On the very next day, she was arrested. And subsequently, she was produced before the Learned Judicial Magistrate First Class UPR, wherein she has been granted bail.
Mhm.
Page 21 is the arrest memo, ma'am. And page number 24 is the bail order. The relevant part would be at page number 25. These are the FIRs based on which the police.
24.
24, ma'am. 25 is the relevant part. Order of the Learned Judicial Magistrate First Class.
This order granted bail to
Bail,
the lady.
Immediately after she has been produced before the
Okay,
Learned.
so then what happened next?
Now, my only apprehension is that after a period of 25 days, my lord, on
Mm.
7/11/2025,
Mm.
I have received a call from the investigating officer of the Women Police Station
Mm.
stating that an FIR has been received and has been kept under inquiry. FIR has been received against me
Mm.
and has been kept under inquiry
Mm.
and further directed me to appear before the police station. If my lord may kindly have page number 26 and 27, these are the a screenshot of call log.
Yes, what we can do is that, we call for a report from the concerned police station.
My-
And maybe we can observe that thin lead courtesy
Madam.
measures, and that can be done. So because particulars of the case would be necessary, right, in the backdrop of this, that can be done at the stage. Heard. With Jamvi Serinki, learned counsel for the petitioner. Though no particulars of any FIR or police case against the petitioner has been described, has been provided, but the petitioner is apprehending arrest in the backdrop of certain circumstances. It is stated and submitted that he was in a relationship with one. Should I write her name or should I give it,
Can write the name.
Miss Menam Tanyang
Like,
Flago? Stop. And due to some, subsequently, he lodged an FIR against her dated 7/10/2025, leading to the registration of Nirjuli PS case number 90 of 2025. Full stop. The said lady was arrested in that case and released on bail upon production. The necessary orders and other documents have been perused to the bail petition. It is submitted by the learned counsel for the petitioner that he has received a call from a police official of which police station?
Women Police Station,
Hmm?
Itanagar.
Hmm?
Itanagar.
Itanagar police station,
WPS Itanagar.
WPS Itanagar, informing that one FIR has been received against him from that lady.
Yes,
Says,
madam. Yes, madam.
from the aforementioned lady, and which is under preliminary inquiry, and that the petitioner has been directed to appear for examination. Have you received any notice under
No, not-
41? However, no notice under section 35(3) BNS has been stated to have been received. They were in a relationship for a couple of years.
6 years.
It is submitted that the petitioner and the informant were and the petitioner and the lady, you write it like that,
Yeah.
were in a relationship for about 6 years, and these are apprehension that the FIR has been filed by the said lady, which will result in registration of a case, giving rise to his apprehension of arrest. Third, and additional PP for public prosecutor for the state. So I mentioned in one case that PP is not available. It will be, I think, additional PP. Additional PP, yeah. PP is not available. We mentioned additional PP is not available. I think you had clarified that at the time from there. Heard learned public prosecutor for the state. At this stage, call for a report from the concerned police station, that is Itanagar WPS Itanagar, as to whether any FIR has been lodged against the present petitioner, and if so, the particulars of the same, including case number. Considering the projected circumstances, it is also directed that till the report is received by the court, no coercive measures may be taken against the petitioner with regard to the incident matter. That will do.
Grateful.
This is the matter. We should give them a week, I think, to get the report. Yes, 17/11 specifically. 17/11? Okay.
Item number 2.
This can be after 17, madam. On 17, I'll be out of station.
Outstation. Okay, not 17. 18, 19, 20.
On 27th, madam.
No, that will be a little late actually, because we don't know. Let us see the FIR. Then, of course, if necessary, the interim can always be extended.
24th.
20. You can also suggest 24.
Grateful.
Item number 2.
Yes.
Oh, sorry.
Lordship, this is a joint application filed under section 522 of BNSSS for causing and setting aside of the FIR dated 8/7/24, registered as Chimpu PS case number 47 of the 2024 under section 331 clause 3 and 305 clause A of the BNSS, and connected charge sheet number 11 of the 25 dated 12/3/2025, Your Honor.
Stealing of LPG cylinder
Yes, Your Honor. And
and
Order.
arrived at a settlement.
yes, Your Honor, they happen settlement and their relatives, immediate brother-in-laws, Your Honor.
It was registered under which section?
331, Your Honor.
Theft.
Theft, Your Honor.
Should we get the scan record? Scan, not record. Case diary,
Charge sheet is closed.
charge sheet. Okay.
Yes, Your Honor.
If you want to see the records, we can. In the meantime, this proceeding can be stayed. That's one
Yes.
option.
Yes,
Right?
Your Honor.
For the PCR losses, it's already submitted before the court.
Yes. It's-
Then
It's in.
Have you
evidence
submitted
system.
any agreement before any court or any police
No,
station?
no, Your Honor.
No.
It may pending before the.
I tried,
There's an agreement. This agreement is annexed here
yes, Your Honor.
as a petition. The original has been submitted in any police station.
No, we have informed, Your Honor, to the court.
Okay. Or if
They
I'm
said-
saying that if suppose you have deposited
I
any
said-
original, then that we'll call for that also.
This, the court suggested that to appear before the High Court, Your Honor, as the sections are non-conformable, Your Honor.
So what do you suggest?
Lordship, will call for the scan copy of the TCR lordship.
Mhm.
In the meantime, it may be.
Yeah, that can be done. Third, good name, please.
B type of dear also.
With learned counsel for the petitioner. The two petitioners herein, namely so and so and so and so, have invoked the jurisdiction under 528 BNSS, seeking quashing of, what is the GR case? GR case has been reached
75, Your Honor.
What?
725.
725.
Yes, 725.
GR number 725 of
24.
2024.
Pending,
Pertaining to charge sheet number 11 of 2025, dated 12/3/2025, which was filed after investigation of Chimpu PS case number 47 of 2024. Full stop. The said police case was registered on the basis of an FIR dated 8/7/2024, wherein the informant alleged theft of her LPG cylinder. Uh, The petitioner number 2 is a relative of Dilip Sriram,
Yes, Your Honor. Brother-in-law, no, sir.
brother,
Brother-in-law.
brother-in-law.
Yes, Your Honor.
But don't you think the informant will be necessary?
no, so it's a joint petition lawsuit.
No,
Oh.
no. See, he's Kenny Sriram is not the brother-in-law of the informant.
Yes, lawsuit, accused is not the brother-in-law of the informant lawsuit.
Accused is the brother-in-law of the informant.
Yes, lawsuit. So that's
So
why
Dilip Sriram is,
Dilip Khanna,
sorry.
Dilip
sorry.
Sriram is the
Kenny
complainant.
Sriram is the accused.
Yes, Your Honor.
No,
Kenny is the accused
thought-
and Dilip is the complainant.
I mixed up. Yes, Dilip Sriram. First. The petitioner, the informant himself has joined this proceeding as petitioner number 1. And the petitioner number 2, Kenny Sriram, is stated to be the accused.
Accused, Your Honor.
Third, Ms. P. Hage Larned, additional PP. Call for the scan TCR of GR number so and so
Lawsuit.
from the court of the Larned.
CGM lawsuit, Chief
C-
Judicial Ministry.
Chief Judicial.
CGM here,
UPI.
UPL.
UPA. Okay. In the circumstances, further proceedings in GR number so and so pertaining to, give the police case number again, Chimpu PS 2724 shall remain state till disposal of this proceeding.
Lawsuit.
But in next date,
Next date, or usually it's next date lawsuit. If that next date. it
Next
can be
date of
lawsuit.
next date we can dispose it.
Yes, lawsuit,
Call for the scan TCR and read.
yes.
Obliged.
Obliged.
State till next date of listing.
Item number 3.
Yes, I mean.
Yeah.
Yes, I mean. Letter, here I'm impugning my letter. Order dated 25/8/2025, my letter, passed by Larnes, CGM,
It's a criminal petition.
my letter, Roy Miller.
Yeah, let us see the impugning order.
In this case, my lord, I'm impugning this both on merit and law, my lord. I will start with the law, my lord.
Okay.
Now,
Page number. Let us-
before coming to this impugning order, my lord, what happened? This the private respondent, my lord, lost one FIR, my lord. In non-action, my lord, he approached SP, my lord. Thereafter, he approached the magistrate, my lord. On magistrate, my lord, under exercising the jurisdiction under 175 BNSS, my lord. Now, earlier it happened to be 156 CRPC, my lord. Has passed this order, my lord. Now, before coming to this order, my lord, my lord will kindly have a look at 153 CRPC, my lord. It used to be, my lord, 156.3, my lord.
The content has remained same, I think. And the
No, such C change has been happened after this, my lord.
Oh, yes. Then
156,
BNSS
my lord.
will need the BNSS.
156.3, my lord.
That was the provision,
Provision, my lord.
original provision.
Original. It used to
It
be,
was a short section at that time.
yeah, my lord.
What a short, yes. 3 sections, 3 subsections. Yeah.
Any magistrate import under section 190 may order such investigation as mentioned above, my lord. Now, under this, my lord, magistrate can direction registration affair, my lord. Now, under BNSS, my lord will kindly have a, now BNSS, my lord.
This is provided 175,
175.
175, my lord.
Now it's 175.
175, 3, my lord.
Okay.
It say, my lord, any magistrate import under
Just a minute, after that, read it together.
Yes.
175 subsection 3.
Three.
So 156 has become 175.
175. Any
Subsection three.
magistrate, my lord, import under section 210 may, after considering the application support by an affidavit made under subsection 4, my lord, of section 173, and after making an inquiry, my lord, candidate making an inquiry as he think necessary, parted N, my lord, and submission made in this regard by the police officer, my lord. Order such investigation, my lord. Now,
So under empowered under section 210.
my lord,
So 210 is $190
yes.
earlier
Fine.
section.
Now,
Empowered, yes, just a minute. And supported under 173. What is 173 now? 173, 3.
150, that is
Information,
information, my lord. Earlier 154, my lord.
154, I see, just a minute. 173 subsection 4. It's in person agreement. Okay, record information and signature.
Now,
I understand. That means the principle laid down in Priyanka Srivastava
yes, my lord.
has been incorporated statutorily.
Yes, my lord.
That's
Truly.
a good way of making law.
My lord. That's why, my lord,
Then people know it.
even my lord, that has been discussed recently in my lord, this,
Okay.
this,
Because a lay person may not know about Priyanka Srivastava.
in my
If
lord.
he sees the law, so he should know. So it has been incorporated, right? We have to know the case law.
Now, therefore, my lord, my understanding, my lord, earlier it used to be like, yes, my lord, after FIR, my lord, SP then magistrate, my lord, 156, my lord. She can directly direct for registration of FIR, my lord.
Mhm.
But after this, my lord, BNS, my lord, before direction of the any FIR, my lord, the hearing of to the police, my lord.
Yes,
is
let us see
required,
the, let us see the provision again. Let us see the provision again.
Provision is my lord, 175.
Yes, let us go back to 175 again.
Any magistrate informed under section
Hmm.
210 may, after considering the application, support by affidavit made under subsection 4 of section 173, and after making an inquiry as he think necessary, and submission made in this regard by the police officer, my lord.
So this procedure has to be followed.
Follow, my lord.
So according to you, in this case,
That does not
that
follow.
has not been followed.
Now, that has been the matter. I have placed one judgment, my lord. This is 2025 AR 970, my lord. I have indicated the FARA, my lord. I will start from 28, my lord. FARA 28, my lord.
This is a recent decision.
Recent
no?
decision, my lord.
Para 25.
28, my lord. I will
Okay.
start from 28, my lord.
Mhm.
However, before part with the matter, we deem it necessary to discuss the sense brought to the scheme of section 156 of CRPC by the enactment of Bharatiya Nagarik Suraksha Sahinta 2023, 29, my lord. Section 175 of BNS corresponding to section 156 of the CRPC subsection one of the section 170 of the BNS is in parameter with subsection 156 one of the CRPC, except for the provision which import the superintendent of police to direct the deputy superintendent of police in it to investigate a case if the nature or gravity of the case so require. Subsection 2 of the section 175 of the BNS is identical to section 156(2) of the CRPC. Section 175(3) of the BNS import any magistrate who is empowered to take cognizance under section 210 to order investigation in accordance with section 175(1), and in this context is in parameter with 156(3) of the CRPC. However, unlike section 156 56(3) of the CRPC, any magistrate before order investigation under 176 the BNS is required to, one, my lord, consider the application supported by affidavit made by the complaint to the superintendent of police under section 174 BNS, conduct such inquiry as he think, and, my lord, considering the submission made by the police officer, my lord. Now, I'm skipping para 30, my lord, 31, my lord, direct 31, my lord. A comparison of section 173 subclause 3 of the BNS with section 156(3) of the CRPC indicate three convenient sense that have been introduced by the enactment of BNS as follows. First, my lord, the requirement of making an application to the superintendent of police upon refusal by the officer in charge of the police station to lodge FIR has been made mandatory, and the application made making an application under under section 175(3) is required to furnish a copy of application made to the superintendent of police under section 173(4), supported by the affidavit, while making the application to the magistrate under section 175(3). Secondly, the magistrate have been empowered to conduct such inquiry as deemed necessary before making an order direct registration of FIR. Thirdly, the magistrate is required to consider the submission of police in charge of the police station as regard to refuse to register the FIR before issuing any direction under 175(3). Therefore, section para 34 and 35 will be relevant, my lord. I am issuing a 34, my lord, will kindly have a look. 34. In the light of the judicial interpretation of the evaluation of section 153 of CRPC by the various decisions of this court and discussed above, it became clear that the
Sorry, I lost track. Which one?
para 34, my lord, 34.
It's on a different page. Yes, 34. In light of the judicial.
In the light of the judicial interpretation and evaluation of the section 153 of CRPC by the various decisions of this court as discussed above, it became clear that the sense introduced by the section 173 of BNS to the existing scheme of section 156(3) merely codify the procedural practice and safeguard which has been introduced by judicial decision aimed at curbing the misuse of invocation of power of the magistrate by unsurplus litigant for achieving ulterior motive, my lord. These are the motive, my lord. According to my lord, rightly pointed out Priyanka by various decisions incorporate, my lord. 35, my lord, further by requiring magistrate to consider the submission made by the concerned police before proceeding to issue direction under 175(3) BNS has affixed greater accountability of the police officer responsible for registration of FIR under section 173, my lord. Now, therefore, my lord, kindly have a look at the
It's a very
impure.
nice judgment.
Right.
It's a very good judgment. Discussed
Now,
very.
if we look into, my lord, this order, my lord, that is a impugn order, page number 21, my lord. My
Right.
lord,
Now we go to
no,
the MP note.
no hearing or no submission from the police at heart, my lord. Page number 21, my lord.
Okay.
May I read, my
Hmm.
lord? Today is the case because necessary order, such and such learned counsel the complaint is present. The complaint such and such is present. The instant petition is filed by the complaint petitioner, Sri such and such, alleged that Sri such and such, proprietor of such and such, submit false and fabricated documents marked as annex number 4 and 5 before Superintendent Tejo. Circle PW to enlist his firm to execute on the PW division. Tejo. It also submitted the petition made by way of RTA applicant has obtained a reply wherein executive engineer WRD Rowing has denied annex number 4 and 5 available in his office, implied that no such documents were issued to such and such, meaning thereby such and such has posted documents to enlist his firm to execute government work. Accordingly, on 27, the petition has filed FIR against such and such at police station Rowing for offense punishable under statutory law. However, even after lapse of 45 days, the OCPS Rowing has not registered the FIR filed by the law by the petitioner. Accordingly, the petitioner has lodged a complaint on 24/4/2000 against the OCPS Rowing to the Superintendent of the Police Lower Dibang Valley District Rowing. However, no steps were taken by the SP Rowing. Accordingly, the petitioner filed instant complaint case such and such for issuance of directive to the OCPS Rowing and SP Rowing to register the FIR lodged by the petitioner on 27. Page the complaint along with the document annex heard the complainant. On page of the petition along with all the record annex, it is found that the allegation made out against the accused person involves the need for thorough investigation as the offense alleged is serious in nature and involve forgery of public document for the purpose of setting. If the case need to be proved, considerable resource will be required and seizure has not to be made, and the police with its adequate resources are best should investigate into the allegation. Considering the same, it deemed that the instant case ought to have been investigated by the police. Accordingly, the case is sent to the OCPS Rowing under 173 BNSS. The OCPS Rowing will register the case and investigate the same and do needful and submit the same in final form expeditiously. The petition is original and document annex along with copy of this order is to send to the OCPS for his necessary action. My lord, they said no submission, my lord, from the police at heart, my lord, in this case, my lord. Therefore, I believe, my lord, this is not in term of the institutional provision, my lord. So
The
it is
case is at the stage of investigation.
in the extreme, my lord. That they just, right.
Prima facie, it appears to be you know, erroneous. But anyway, you are appealing for the prosecution.
Yes, my lord. Before relying on the same judgment, my lord, I would like to rely a judgment of the FX court regarding the, your lordship, the precedent of the apex court.
Mhm.
Your lordship, it is well settled that the decision is only an authority for what
What
is
it
actually decides. What is its essence in a decision is its ratio, and not every observation found therein, nor what logically follows from various observations made in it.
Yeah.
That has been decided, your lordship, long time back in 1968, my lord, the AIR, 1968. Why I'm relying this judgment, my lord, I will come to that, my lord. 1968 SC 647, my lord. My lord, will find in para 13, my lord. I have just highlighted, my lord. It's a very long paragraph. So the relevant portion, my lord, I've just highlighted. Now, your lordship, I will rely this Om Prakash Ambedkar judgment, which my brother has relied, my lord. My lord, there may be slight variation in the paragraph. So mine is, my lord,
Om
SCC.
Prakash Ambedkar, this
Yes,
one.
my lord. Om Prakash, my lord, that is the SCC one.
SCC makes variations in para something.
Yes, my lord. Yes, my lord.
Om Prakash.
My lord, here we have to understand what aspect the Honorable Apex Court was deciding, my lord. Here, your lordship will find in para 26 and 27, my lord, basing on which the Honorable Apex Court has quashed the FIR, my lord. The relevant portion is in para 26 and 27, my lord.
Hmm.
The incident is of the year,
Wait, just a minute.
yes, sir.
20, we're reading 25?
20, my lord, the 26 and 27. Then I will come to other para.
20, the incident is of year
Yes,
2012.
yes. The incident is of the year 2012. The court, while admitting the appeal, has stayed the investigation. In the overall view of the matter, we are convinced that no case is made out to put the appellant accused to trial for the alleged offense. Continuation of the investigation by the police will be nothing short of abuse of process of law. On this aspect, the Honorable Apex Court has quashed the matter. Now, your lordship, the successive paragraph, it was just an Supreme Court outlining the precedent as well as, your lordship, the new amendment, new insertion in the
Yeah.
provision of the BNSS.
Mhm.
Here, the Apex Court has not dealt with the aspect that if this procedural
Not
aspect
followed.
has not been followed,
Then
what?
what?
Will be the outcome? Now, that aspect has been considered in, my lord, Anurag, Bhatnagar, and another, my lord. Here, your lordship, because the procedure, your lordship, which has been referred in 154, subsection 1 and subsection 3. Initially, your lordship, the person has to approach the police. If not, then SP. If not SP, then magistrate, my lord.
Mhm.
And to that effect, the compliance of subsection 1 and 3 has to be filed before the magistrate, although there is no any specific format, by in the way of complaint and supported by an affidavit. That is, your lordship, in Priyanka Srivastava, it is well settled, my lord. The law is prevailing as on that, and it was just your lordship reflection of the law, which has been already decided by the Apex Court.
Incorporated in the statute.
Yes, my lord. It is not a new law, my lord.
So now,
My lord, now your lordship may kindly come to, my lord. Here, your lordship, I am relying the judgment of this case, my lord. Here, not even, my lord, the police, they have approached the police, not even the SP, directly to the magistrate. And Apex Court has held that the prima facie requirement is the commission of cognizable offense. My lord, may kindly come to para 17, my lord. This is the judgment reported in 2025 SCC Online SC 1514.
okay,
Yes, para 17, my lord.
just a minute. Huh?
Yes, ma'am. And it was further followed also, my lord.
Okay.
Yes.
Para
Para 17, my lord.
70,
17, my lord.
17.
Yes, ma'am.
Mhm.
My lord, the point for determination, my lord.
Mhm.
On the basis of the submission of the parties, the following points call for determination. Roman 1. whether an application under section 156 subsection 3 of the CRPC could have been filed without approaching the police authorities. Now, Your Lordship, the subsection 3 of 175 says that the police must be given opportunity. Why? Because to clarify whether any material has been found or any inquiry has been made or not, my lord.
Yes. Then why the FIR has not been registered?
Yes, Your Lordship. For check and balance, my lord, this para 35 is very clear, my lord. To check and balance, that police should not every time add in not registering the FIR, even if disclosed cognizable offense. So now, my lord, may come to para 19 onward, my lord. Here, the Supreme Court has, my lord, explained, my lord, even if these aspects are not taken into consideration, it will be a mere irregularity, but it will not vitiate the FIR, my lord. My lord, may I read para 19 onward, my lord.
Yes.
Para 19, my lord. It is a settled law that one of the modes for setting criminal law into motion is by giving information to the police authority in accordance with section 154 CRPC, whereupon if a cognizable offense is prima facie made out to the satisfaction of the police, it may investigate into the offense even without the permission of the magistrate. The information so given is ordinarily called the purse information, though this temporal terminology has not been used under the CRPC. Now, para 21. Subsection 3 of Section 154 CRPC lays down that if the information of a cognizable offense given to the officer in charge of the police station is not being recorded or is being refused to be recorded, the informant may send the substance of the said information to the Superintendent of Police concerned in writing and by post, who upon being satisfied that such information disclose a cognizable offense will either direct for the investigation of the offense or may himself investigate the same. A plain and simple reading of section 154 CRPC as a whole make it imperative upon the informant to first approach the officer in charge of the police station for the purpose of lodging an FIR in respect of cognizable offense, and where the police refuse to record such information, the remedy is to approach the concerned SP. It is only when no action is taken even by the Superintendent of Police, the information of commission of a cognizable offense is not being recorded by the officer in charge of the police station or even by the SP, that the person aggrieved or the informant may move the court of the magistrate concerned to get a FIR registered and lodged with the concerned police station. Subsection 3 of so and so, now para 24, my lord. Section 190 of the CRPC empower the magistrate to take cognizance of an offense in 3 contingencies, namely 1. Upon receive a complaint of fact constituting the offense, upon a police report of such fact. 3. Upon information received from any person other than the police officer or upon his knowledge that such an information has been committed. In view of the provision of section 190, read with section 156, subsection 3, the magistrate is empowered to take cognizance of any offense, not only on the basis of police report submitted under subsection or under section 173 of the CRPC, consequent to the investigation pursuant to the FIR, but also upon receiving a complaint of fact from any person other than the police officer or in his own motion. On the conspicuous reading of the provision of section 154, 156, and 190 of the CRPC together, it is crystal clear that an informant who wants to report about a commission of a cognizable offense has to, in the first instance, approach the officer in charge of the police station for setting the criminal law into motion by lodging an FIR. However, if such an information is not accepted by the officer in charge of the police station and he refuses to record it, the remedy is of the informant is to approach the Superintendent of Police concerned. It is only subsequent to availing the above opportunity, if he is not successful, he may approach the magistrate under section 156(3) CRPC for necessary action or of taking cognizance in accordance with 190 of the CRPC. In the instant case, a bare perusal of application filed under section 156(3) of CRPC dated so and so would reveal that the informant therein has simply stated that an offense under section so and so has been committed, and that the informant has approached the police officer several times, but the informant approached the police or the SP. The application nowhere states that the informant has ever approached the officer in charge of the police station or for lodging the FIR in accordance with 154 of the CRPC, or that on refusal of the record such information, he has availed the remedy of approaching the SP, Superintendent of Police concerned. The mere bold allegation without any delay, detail, or proof thereof that the police authority were approached several times is not acceptable. Now, in Sakri Basu versus State of UP, it has been observed that if a person has a grievance that the police station is not registering the FIR under 154 CRPC, then he can approach the SP under section 154 subsection 3 of CRPC by an application in writing. Even if that does not yield any satisfaction report in sense that either the FIR is still not registered, or that even after registering no proper investigation is held, it is open to the person aggrieved to file an application under section 156(3) CRPC before the magistrate concerned. In other words, the court reiterates that the proper procedure has to be availed of and follow before moving the magistrate under so and so. It is well recognized in law that the person aggrieved must first exhaust the alternative remedies available to him in law before approaching the court of law. In other words, he cannot ordinarily approach the court directly. In the case at hand, the fact revealed that the informant has neither approached the officer in charge of the police station or the superintendent of police concerned as contemplated under section 154(1) and 154(3) of the CRPC, but has directly gone to the magistrate under section 156(3) of the CRPC. In such a situation, the magistrate ought to have ordinarily entertained the application, ought not to have ordinarily entertained the application under section 156(3) so as to direct the police for registration of FIR. Rather, it ought to have relegated the informant to the first information or approach the officer in charge of the police station and then the SP. The magistrate, while passing the order dated 1/7/2005, directing for registration of FIR in exercise of power under section 156(3), has not considered the above aspect as to whether informant has exhausted his remedy available in law before approaching under section 156(3) of the CRPC. In the fact and circumstances of the case, as the informant has directly moved the magistrate under section 156(3) of the CRPC without existing his statutory remedy, the magistrate could have avoided taking action on the said application and could have refused to direct for registration of the FIR. However, as entertaining an application directly by the magistrate is a mere procedural irregularity, and since the magistrate in a given circumstances is otherwise empowered to pass such an order, the action of magistrate may not be illegal or without jurisdiction. To sum up, the magistrate ought not to ordinarily entertain an application under section 156(3) CRPC directly, unless the informant has able and exhausted his remedy provided under section 154(3) CRPC. But as the magistrate is otherwise competent under 156(3) CRPC to direct the registration of the FIR, if the allegation in the application complaint disclose the commission of the cognizable offense. We are of the opinion that the order so passed by the magistrate would not be without jurisdiction and would not stand vitiated on this count. The magistrate, by order dated so and so, has simply direct for registration of the FIR so as to set criminal law in motion, but has not exercised his power under section 190 of the CRPC of taking cognizance thereof. In such a situation, the order so passed by the magistrate, though irregular, is of no prejudice to any party, must lest to the VLS. Therefore, it is not appropriate for this court to interfere in the matter or with the order of the magistrate dated so and so, or with order impugned passed by the High Court. Now, my lord, here
So,
in the present case, my lord, the police has been
so
approached, my lord.
just a minute.
Yes.
So in such a situation, which you have already read, the order so passed, though irregular, is of no prejudice. That means it's not an illegal.
Yes, my lord.
It's not
And they, my lord, if even the irregular order will be stand vitiated if they demonstrate that it caused prejudice to them, my lord. That is the law, my lord. So now here in this case,
the thing is that, okay, you complete it.
Yes, okay.
Then I'll-
and now, my lord, the only their ground is, my lord, that the police has not been given make any submission. But this is an admitted fact. For a 45 days, the police has not initiated any action. And after approaching the magistrate, after producing certain document, my lord will find the impugned order also, my lord. This is not passed mechanically, my lord. Because, your lordship, one more judgment is there. It says, if the allegation is simple, and magistrate can convert into a complaint case and make an inquiry by himself, then the magistrate should not in a mechanical way direct for investigation of the matter. But if the allegation and the material to be collected it's required to be required for adjudication, then state machinery can be set into motion by directing for registration of FIR, your lordship. This is also well settled, my lord. But now, my lord, merely because the giving an opportunity to the police authority, whether the order passed by the magistrate for investigation of the case will be vitiated, my lord. At least that this is an irregularity, my lord. Because, my lord, the 175 subsection 3.
So that is what I'm saying, or
Yes.
what comes to my mind, if you permit me to just interrupt you, what comes to my mind is that if we say that this would be, this will not be an illegality, which has been the principle which has been laid down,
Yes, my lord.
that irregularity, it would by implication mean that those provisions of 175 subsection 4,
Yeah, 3, my lord.
subsection 3 will be directory,
Yes, sir.
not mandatory.
Not mandatory.
And if it is directory, then it clashes with Priyanka Srivastava.
Yes, my
Because
lord.
Priyanka Srivastava principles have been incorporated in the subsection,
Yes, my lord.
right? Priyanka Srivastava, that was a constitution bench, or that was a, I think,
Priyanka
at least 3 judge bench, definitely.
Yes, my lord.
Priyanka Srivastava still holds the field, right?
Yes,
we
ma'am.
do not, we do not disagree with this, that Priyanka Srivastava
Yes, ma'am.
principles hold the field. And Priyanka Srivastava insists on making this affidavit
Yes, my
and
lord.
all that. Now the only new thing, I think, which has been incorporated in the statute is hearing the police officer.
Yes, my lord.
This has been added.
And my lord, in this case,
If it is directory regarding the affidavit part, suppose,
yes, my lord, and
then don't you think it will clash with Priyanka Srivastava?
yes, my lord, but
If
this
we hold it to,
this judgment has been, your lordship,
Because-
further, your lordship,
because another thing is that which has been said in this judgment, both are new judgments.
Yes,
okay,
ma'am.
and this is newer. This is in July.
yes,
This
ma'am.
is in this January. In this judgment, the January judgment, which he has placed, the reason for why this kind of changes have been incorporated and which was laid down in Priyanka Srivastava has been explained, that you do not use the powers of the magistrate under 156(3) for any vested interest. The police is mandated, even Lalita Kumari comes into play.
Yes, my lord.
That once there is once the information discloses a cognizable offense, the police is bound to register an FIR.
Absolutely.
The only limited window which has been provided to the IO is that he can make an inquiry,
Yes.
not whether, only to find out whether, he cannot make an inquiry into the offenses. He can only make an inquiry to ascertain whether cognizable offense is made out or not.
Yes, my lord.
That much inquiry.
Yes,
So that is there. Now, despite such a provision, if a person comes directly to the magistrate, he has his own accountability.
Yes,
He has to explain where he has got.
Yes.
In my opinion, this provision of hearing the police officer is a very important, because the police officer must, make his reasons. It increases the accountability of the complainant as well as the police officer, that the registration of the case is the first duty of the police
Yes,
in case
madam.
of a cognizable offense. So what are the reasons you have not, it may be that,
Yes.
it may be that there are no allegations, do not make out anything. The
Yes,
police may have been justified in not registering an FIR, or there may be some vested.
Yes,
So
ma'am.
this process have been incorporated.
Yes,
in
ma'am.
my-
And your lordship, the one more aspect is there, but my lord, because of this non-submission of the police, whether the victim should be made suffer, my lord. This is one of the aspect also, my lord. And the second part, my lord, if suppose, my lord, the police, my lord, I'm not saying, my lord, this is subject to the interpretation, subject to the adjudication by this honorable court.
This is
my lord.
the-
And so far as-
This is the evolving law.
Yes, my lord. And so far as the Priyanka Srivastava matter is concerned, in this case, Priyanka Srivastava matter has it duly followed the procedure which has been laid down in the Priyanka Srivastava matter. Here in the present case, the OC has been approached. When it was not, my lord, when it was not registered, he approached the SP. And after that only, my lord, he approached the magistrate. The only thing that remains is, my lord, the submission by the police.
No, affidavit.
But affidavit part, my lord, that part they are not assailing, my lord.
Affidavit you filed?
Affidavit there, my lord. Is there, my lord?
Affidavit is.
Yes, only, my lord, submission of the police.
Oh, submission.
Only submission of the police. For that, my lord, the victim should may suffer, and that too, my lord.
No, that can be easily addressed. We can really send it back, and they can, the police can be heard.
Yes, my lord, that can be done. No,
Can be done.
that can be done. Yes,
For that, the entire prosecution may not be.
yes, my
quashed.
lord.
That
Yes,
is,
absolutely.
It
my
does
lord.
not become illegal.
Yes, my lord. That can be then. The matter can be remanded back at this stage only, my lord.
I thought the affidavit also, affidavit is there.
There, affidavit is there, my lord. Only the submission of the police, my lord. Only that part, my lord.
That, in fact, that could be helpful to the other side, both sides also, because the court will hear why he has not registered.
But my lord, for that application, they don't have any stand there. They have done any right there to make submission, because your lordship,
Police.
only police, they are the prospective accused right now, my lord. Because during the course of investigation, my lord, they have to cooperate. If suppose register,
No hearing during the.
yes, exactly, my lord. Only after
This is
cognizance or
judgment
issue of summon, they have a right to defend. No, but not at this stage. Although at this stage they are challenging, but not at the former stage, my lord.
So,
My lord,
oh yeah, you reply. Otherwise, what else can be done at this stage today? No.
I start my submission with, I submit on the merit also, my lord. Now, in the middle, he has started, my lord. Now, before starting on the merit, my lord, his reply, my lord. I totally in concern with his first judgment, my lord. Ratio, my lord. Any ratio need to follow on the peg of the judgment, my lord. That I totally concord, my lord. Therefore, my lord, and my lord will see the last judgment submitted by him, my lord, is about 156.3, my lord. 156.3, my lord. That's why I indicated first, I read out the 156.3 CRPC, my lord. Thereafter, I read out the BNSS, my lord. His judgment, my lord, that this is mere irregularity, my lord. Even if, my lord, suppose person does not appear before the IO and the SP, my lord, then also magistrate has a authority to take cognizance, my lord. That ratio is in term of the 156.3 CRPC, my lord. Now, thereafter, my lord, legislature has subsequently substantial sense in this provision, my lord. That's why I did 156 simply say, my lord. Simply it say any magistrate in power under section 190 may order such an investigation as I mentioned above. In the light of this judgment, the last judgment was clarified by the Supreme Court, my lord. Now, what happened thereafter, my lord? Thereafter, this BNS has come, my lord. Now, in BNS, my lord, the legislature, in their wisdom, my lord, has inserted this particular provision, my lord, before ordering, my lord, any investigation, my lord. Hearing of the police is necessary, my lord. Now, that had been interpreted by my judgment, my lord, particularly at the Apex Court, my lord. Apex Court say, my lord, it para 35, my lord. Further, by requiring the magistrate to consider the submission made by the concerned police officer before proceeding to issue direction under 164.3 BNSS, my lord.
Yes, more accountability.
Therefore, my lord, my humble understanding, my lord, in terms of the new enactment, my lord, and in terms of the Apex Court law, my lord, it is mandatory, my lord. That in the judgment relied by the other side is about 156.3, my lord. 156.3, there is no such provision, my lord, mandating the hearing of the police, my lord. Now, therefore, my lord, this order, my lord, without following the provision of the law and the law laid and the Apex Court in this Om Prakash Ambedkar, my lord, I humbly believe, my lord, he is besetted, my lord.
I get your point that this judgment is with regard to the requirements
Under
which existed on the basis
CRPC,
of
my lord.
Priyanka
Priyanka
Srivastava.
Srivastava,
That, affidavit has to be filed. No, application has to say, my application has to say that I have followed the steps. I have approached the IOC, no FIR, no
Yes.
registration.
Yes, ma'am.
Then I go to knock the doors of the SP,
Yes,
no
ma'am.
registration.
And
Then I come
that
to
does-
the
my
court
lord,
and I have to state that on affidavit.
yes, ma'am.
yes.
And
That is completed. That is done in this case.
That is done in
It
this
is
case.
done.
Very
And
fair.
in-
His contention is that now I get that this judgment, if I've understood correctly, Learned Counsel has said that this judgment was basically, delving into 156
Yes.
and the interpretation of Priyanka
Yes.
Srivastava.
Yeah.
Here, this judgment has discussed about the police hearing, and police hearing, he contends that the police hearing is mandatory.
Yes, my
And
lord.
therefore, this is the issue.
Yes, but my lord,
It is-
here that aspect has not been dealt with. Whether if it is not done, it will vitiate or not.
Yeah.
That is the aspect.
My humble understanding, my lord,
Yes,
this is
it has
clarified,
not-
my lord.
Yes, my lord. Because my lord,
35, my lord.
Because as you say, rightly said, that issue, whether non-hearing the police would vitiate,
Yes.
it was not in dispute.
and court was not dealing with that issue, my lord.
These are the
Just
apex
procedure
court-
has been outlined, my lord. These are the
the
procedure which
apex
has to be
court
followed.
Can explain law, right?
Exactly,
So
my
that
lord.
was the
Absolutely, my lord.
explanation of this.
Yes, my lord.
No.
Absolutely.
Therefore, my lord, my humble submission, any, my lord, direction by the court, my lord, judicial officer in violation of the some law, my lord, supposed by the statutory provision, my lord, I will say, my lord, it truly beset the whole proceeding, my lord.
Yes, I think what we can.
My humble submission, it is on merit also, my lord, I have a case, my lord. If my lord allow, my lord, I'll.
No need actually. We
It
are-
is my humble submission, my lord.
Because this gate we have to pass first. So what I can do is this order, if you know, in the absence of anything else, it appears prima facie that the section has that requirement.
Yes,
right?
madam.
So the importance of the section has also been emphasized by the Supreme Court, but as you rightly said, that was not in dispute.
Yes,
So that point has not been decided.
yes, yes.
Because the courts have limited scope to go into academic exercise.
Yes,
right?
exactly.
That will be waste of time. So we can, remand it.
Remind it back and give,
This will be interfered with, but then remand it back.
yes, remind it
And
back.
then,
madam.
Yeah, in consequence of this, my lord, FIR being the register, my lord, that also need to be interfered, my lord. Thereafter, later, magistrate pass, new order, my lord.
Yes, absolutely. It
Yeah,
has
by
to be, my
following-
lord, this order has to be interfered with a direction to the magistrate that opportunity of submission to given to the police and then pass an order, my lord, in
My-
accordance with the law.
Yes, ma'am. That can be, my lord.
Because as on that, my lord, yes,
because I have slightly forgotten actually. The police hearing principle was not there in Priyanka Srivastava, right?
no, not there, my lord.
yet.
Only affidavit, my lord.
So the lawmaker, the drafter has incorporated this.
Yes, my lord.
Additionally, my lord, yes, I have invoked a,
So the
my lord jurisdiction.
law drafter has incorporated Priyanka Srivastava and the new concept.
Submission of the police person.
Pardon, my lord, yes, I have invoked my lord inherent jurisdiction, my lord.
Mhm.
I pray, my lord, taste the whole case on merit also, my lord. Therefore, my lord, see, my lord, what happened in this case? No, my allegation, my lord, will kindly say FIR, my lord. What is the FIR, my lord?
No, I think that would be better. Let the procedure be completed. And suppose suppose after completion of the procedure, if there is another registration of another case,
Ma-
you have a fresh cause of action.
Yes,
And in
yes,
that case,
absolutely.
we can see the full merits.
Yes.
Okay, because the thing is that if we see the merit, of course, if
Yes.
we see merits and find that there's nothing, then of course, it can be interfered with, but let this exercise be completed. I think that would be fair enough.
Therefore, then, my lord, impugn order and the consequential FIR, my lord, will cause, my
I
lord.
will not write much,
Yes.
write it concisely. Apni logo, time over, we'll have time. Unanimous, heard learned counsel,
Help me, my lord.
L permit for the petitioner and learned additional PP for the state.
Yes.
We go.
Sorry, but one aspect, I have made a private respondent, my lord, here in my lord. One complainant is a private respondent, my lord. In this case, my lord.
Complaint,
Complainant, my
My
lord.
lord, complainant, informant, he has made a party. My lord, since he's going to remand back, since the procedural aspect has not been considered, so
okay.
no prejudice will cause.
You want that, so if we can issue notice,
No, my lord, it's okay, my lord. I'm
But
going, my
it
lord.
has to be stayed. Then.
There will be delay, then my lord, the investigation, it will hamper the investigation part, my lord, if it is registered.
The instant, the petitioner herein, namely so-and-so, Noon Party has invoked the jurisdiction under 528 BNSS, seeking interference with order dated 25/8/2025, passed by learned CJM Lower Dibang Valley District, Rowing, in Miss Criminal 24 of 25, dash whereby accepting the application of the informant / complainant under section 175. 175, it is subsection 3 of BNSS within bracket, corresponding to section 156(3) CRPC, was pleased to direct the police to investigate the FIR dated ... lost by the informant. Case has been registered, right?
Yes, madam.
Resulting in the registration of full stop. The aforesaid direction of the learned magistrate, after compliance by the police, resulted in registration of rowing PS case number
59 up to 2025, my lord.
2025 under sections.
318 sub clause 3.
We'll write it. Don't worry, we'll write it. We'll write it. Dot, dot, dot. Charge sheet has also been filed.
No, my lord, under investigation.
Investigation. No, I mentioned the charge sheet
No, my lord.
on the ground that charge sheet has been. No, you mentioned about one charge sheet. That's why by mistake. It was in the cost title in the matter of on page 4. Portion of the case against on the ground the charge sheet against the petitioner has been. It's by mistake come, I think, no?
Mistake, my lord.
Just,
I'm sorry, my lord.
the drafting.
Photo, copy paste.
When we have to be always careful. I have had a very embarrassing episode when I was in practicing. In the entire contempt petition, it was we withdrew it. It's okay. I understand. But it happens sometimes. It's not the primary contention of the petitioner side is that the direction for investigation was given by the learned magistrate without complying with the procedural requirement of section 175 within bracket subsection 3 BNSS, especially the hearing of the investigating officer. Before proceeding further, the said statutory provision may be reproduced herein below. In support of this contention, the petitioner has relied upon decision of the Honorable Apex Court in the case of Om Prakash Ambedkar versus State of Maharashtra and others, reported in the 2025 in SC 139. And it was Supreme today, and this also you give, and we'll give it first up. The Learned Counsel in the course of the hearing has taken the court through various relevant paragraphs of the aforesaid judgment, wherein the Honorable Apex Court has explained the changes brought about by the legislature in section 175 subsection 3 pertaining to powers of the magistrate to direct investigation by the police. For this purpose, section para 29 of Om Prakash Ambedkar may be reproduced herein below. 29 and 35. 29, 34 and 35. Para 29, 34 and 35 has been written down. It is submitted by the petitioner counsel, learned petitioner counsel, that the application preferred by the informant before the learned magistrate was accompanied by an affidavit, but the hearing of the IO as mandated by section 173/75(3) was not done, and contents in this regard that the said hearing is mandated by law, failing which the order is for failing which the order directing investigation is vitiated. Good stuff. That's very fair submission we have seen. Very good. I've seen, very happy with the councils. They make fair submissions. Yeah, a lot of fair submissions. On the other hand, the learned public prosecutor submits and that the non-hearing of the police officer might be a procedural irregularity at best and would not make the order illegal or the investigation untenable in law. In support of this contention, the learned prosecution has also relied upon a recent decision of the Honorable Supreme Court dash Anurag Bhatnagar and another versus State NCT and another, reported in 2025 SSC Online SC 1545. The learned prosecution has also taken the court through some of the relevant paragraphs and contended that in the said judgment, which was with regard to section 156(3) of the CRPC, the Honorable Apex Court had held that though the petition of the complainant was not accompanied, did not disclose about approaching the superintendent of police and the accompanying affidavit, the same, I think affidavit aspect was not discussed, I think.
Yes, my lord.
Has not stated about approaching the superintendent of police as required under section 156(3) CRPC, and the principle laid down in Priyanka Srivastava versus State of UP, citation.
My lord, 154(3).
154(3).
Yes.
No, the Priyanka Srivastava 156(3), how it is to be
Yes,
exercised.
my lord.
154/156(3).
Yes, yes.
The court, I'll fine tune it, the court merely stated that the said order is irregular and also would be irregular at best, and also subject to the test of prejudice to the party. The relevant paragraphs being para number ... I will tell you, all the paragraphs may not be necessary, but para 34 would be necessary. Okay, 33, 34 are reproduced here in below. Full stop. The complainant, the petitioner, accused petitioner has included the informant / complainant at respondent number 2. I have carefully perused the impugn order of the learned magistrate dated. Where's the impugn order? Just help me with the page number. I will.
21, madam.
21 to 20. Dated 25/8/25.
Impugn order dated 25/8/2025, passed by the learned magistrate. Stop. Stop. It is stated in para 9 that the learned magistrate perused the petition along with the records annexed. Stop. From the record, there is no mention about conducting any hearing of the police officer as provided for under sections 173, 75(3) of BNSS. Full stop. Thus, from the impugn order, it is clear. There will be repetition. I think. Thus, it is clear that one of the limbs of section 175(3) pertaining to hearing of the police officer was not done before passing the said impugn order dated 25/8/2025. Full stop. Since the judgment in Om Prakash Ambedkar was with regard to 156(3), the court did not have an opportunity to go. The court in that case was not required into did not go into the aspect of whether the hearing of the police officer is a mandatory requirement. Full stop. Oh, this is the same judgment, right? It is the same judgment.
Same judgment, madam.
Yeah, you told me. In Om Prakash Ambedkar itself, Supra itself, though the Honorable Apex Court has explained the importance of hearing given to the police officer in para 35 thereof, but it has been perhaps rightly contended by the learned prosecution that the Honorable Apex Court was perhaps not required to go into the question as to whether non-hearing of the police officer would vitiate the order of directing investigation. Thus, it appears that the said remains an open question, perhaps to be addressed at a later stage in the evolution of this law. In the instant case, upon perusing the materials and considering the submissions of the learned counsels on both the sides, considering the fair submissions of the learned counsels on both the sides, I am of the considered opinion that perhaps the case can be disposed of at this stage itself by interfering with the order and and giving, you write it in the order. Consequently, the order dated 25/8/2025 passed by the learned CGM rowing, CGM Lower Dibang Valley District rowing in GR number in miscriminal case 24 of 2025 is set aside and quashed. Consequently, the what is the PS case number?
Rowing PS case number 59 of 2025, my lord.
Rowing PS case number 59
My lord.
of 2025.
25, my lord.
And the consequent investigation are also required to be interfered with, and they are accordingly quashed. However, the informant slash complainant would be at liberty to file a fresh application before the learned magistrate, complying with the provisions under section 175(3) BNSS. And if done so, the learned court may adjudicate such petition
My
by
lord, since the informant is not present today, my lord, what my humble submission would be, my lord, let my lord this matter may be remanded back to the learned CGM, my lord, with the giving opportunity to the informant and
That's what I'm
complying. Yes, my lord has directed that info. If
no,
informant-
yes, it can be. He's not there. How will he know?
Yes, my lord has directed the
That
informant.
has
if-
to be changed.
Okay, yes.
The court can issue notice then.
Yes, my lord, the complaint is already filed. Everything is there. Only their part is the police part, my lord.
Yes, police hearing.
Yes, that can be done by the magistrate itself, my lord, and the magistrate will issue the notice to the informant, your lordship, before done it.
Because we have,
May remand it back, my lord.
no, we have quashed the FIR also. No? Unless, if we quash this order of directing investigation, the FIR also has to be.
Yes, my lord, absolutely, my lord.
FIR quashing means investigation so far gone.
Yes, for non-compliance of my lord. this-
True.
So,
So now, you kindly guide me.
yes, my lord.
Thank you, I'll be grateful. So what would be the most effective way?
My lord, the matter may be remand back for reconsideration,
This quashing has to be done.
Yes, quashing, but my lord, that part is there, my lord, that complaint is not gone, my lord. Only the order directing the investigation is gone, but the complaint which is pending before the match, now the complaint will remain pending, my lord. If the other part, the subsequent order is gone, my lord, but the complaint,
Then what about the registration of the case and the investigation so far?
no, my lord, the complaint case is registered with different number, my lord. And subsequently, when order is passed, the investigation has been carried out. Now, my lord has interfered with the investigation as well as, my lord, the direction for investigation.
Complaint case is registered separately.
Yes, my lord. My lord, they have annexed the complaint, my lord.
No, sometimes the petition itself is registered as a miscase and disposed of like that.
My lord.
Now the case, I don't think
My lord
complaint
has
case,
not-
because it's a police case.
My
I
lord
don't
has,
think any complaint case has been registered.
My lord has-
Let us, we may be wrong also. Because that's what I was looking for. It has only miscriminal 24.
my lord will find in page number 25, my lord. Page number 25, my lord. This will be still there, my lord.
20?
Page number 25, my lord, of their petition.
No, it has not been numbered actually.
And-
it has not been numbered. It is in the form of a miscase.
Annexure
only.
2, my lord.
Because
Annexure 2, page 23, my lord.
Annexure 2,
Miss
page
criminal,
23.
my lord, 23, my lord, sorry, my lord. Annexure 2 series.
No, it is registered as a miscriminal,
Yes, my lord.
not complaint case, miscriminal.
Yes, miscriminal, my lord, for exercising 170.
So
It can be
miscriminal-
converted also, my lord, later it is upon the
The only
discretion of the
thing is
magistrate.
no, this is okay. Otherwise the court can issue notice the complaint.
Yes, my lord, to reconsider, my lord, this miscase will be there since it was earlier disposed of, but my lord restored this, my lord may kindly restore this application, my lord. Because it was disposed of and direction was given.
Set aside and quashed, you end there. Huh?
Yes.
Then you next part you just cut it. It will be redictation. Okay, so
His criminal number 24 of 25 may be restored And accordingly, my lord, on the basis of, in accordance with the procedure of the 174(3), so and so, my lord, the matter may be considered by the concerned magistrate, my lord.
Whereupon if the magistrate is satisfied, then
Yes,
fresh direction will be given, whereupon a fresh case will be registered.
yes, my lord.
Fresh case. will be
Yes,
registered.
and even, my lord, the magistrate can go for registration of complaint itself, my lord. It is upon,
That's up to him.
yes, my lord, it's up to him. So this may be restored, my lord.
At this stage, the learned additional PP submits that perhaps the direction can be issued to restore Miss Criminal 24 of 2025, wherein the impugn order was passed.
Yes.
But after the quashing the impugn order, what can we restore?
My lord, only that part, my lord, this submission by the police has not done, but
Can be restored, and that's a submission, so very good. Can be restored, and magistrate can pass consequential orders
yes.
in terms of this judgment. Another thing which has come to my mind is that the magistrate can register, the court can register a fresh miscase
Yes,
with
my
the
lord.
existing materials.
Yes,
fresh miscase.
yes,
I
my
think
lord, that can be done, my lord.
that appeals to me more, no? Because what question is coming to my mind, bothering me, is that the only order which has been passed in the miscase has been set aside. So after that, will anything survive to restore?
My lord, the
Why not
question,
a fresh miscase?
My lord,
It's a ministerial work. Only.
yes, my lord, again, one thing is, my lord, if, my lord, because it is accompanied with the affidavit, as we pointed out, my lord.
It will not be
If-
there.
Yes, if, my lord, if this is gone, it is amounting to quashing the, my lord, his application before the magistrate, my lord. It's only, my lord, for the procedure under section 175 subsection 3, that to the submission by the police, non-compliance of that only the matter has been remanded back.
I
my lord.
was thinking that I will
For
say
that, my lord, I believe my lord has given the liberty to the complainant, my lord.
liberty, but the complainant has to be informed by the
Yes,
court.
absolutely, my lord. But
Informed by the
I
court.
believe he is interested party in this case, my lord.
And
So
he'll be informed by the court.
He should be informed, my lord.
Okay.
Liberty is given and he can approach, my lord.
Okay, then that dictation will only remain in the Mikhapi decision. No?
So in-
The complainant, informant complainant will be at liberty to
Yes.
file a fresh application
Yes,
before the learned magistrate in compliance with the provisions of section 175(3) of BNSS. So for this purpose, the learned court, on the basis of this order, shall issue a notice to the said complainant. Full stop. If such a new complaint is filed by the informant side, for the informant side, the learned magistrate shall pass necessary orders on the question of directing police investigation after ensuring full compliance with the provisions of section 175(3) BNSS, including the hearing of the police officer. The instant criminal petition stands disposed of. The assess stands disposed of on the aforesaid terms. A copy of this judgment order shall be sent to the learned CJM West, this Lower Dibang Valley District, Rohit.
Yes, yes.
Highly evident.
Should do. Procedural matters, actually, sometimes we should.
Yes, my lord.
You are also not wrong, actually. But let's see, I think this will be, but he has to be informed.
Yes,
given notice.
absolutely. But if CGM informed, then that will suffice, my lord. And since the liberty has
Like
been
it
given.
is, Naraji petition, the
Yes.
notice is always issued,
Yes.
like that. Particular subject. So this disposes of.
Yes.
It's an interesting point, I've first time. That's for principal seat. Oh, yes, you can get it connected. In the meantime, you can proceed. When they connect, then we'll deliver. Okay, what's up? There, no? Okay, okay. Somebody, yeah. Uh,
One is present. And talking stuff.
no one is present, so I can pronounce the order. Pronounce the order. The criminal petition is dismissed for the reasons stated therein.
Dismiss.
Dismissed and disposed of. Give it. Vince,
May I also-
I'll sign it. Yes.
I beg to mention item number 27. We have taken consent from other parties, government.
No, no name is shown on the other side anyway. Actually, item 27. You are Mr.
B. Sibu.
B. Sibu, Learned Counsel. For the petitioner side submits that with the consent of the other side, he seeks an adjournment of the matter. List prayer is allowed. The respondents have not appeared. Name is not, oh, you are appearing. I think. Got it. How many respondents are there? I don't have
Yeah,
the file. Two respondents. Okay, One has, service is complete.
No, awaited, still awaited.
Services awaited. Then, with the consent of the other side, learned counsel, then appears, government advocate appears on behalf of respond number 2. So service upon respond number 1 is stated to be not completed. You will await,
Yes,
await, full stop. Place the matter after
2 weeks.
2 weeks.
Lots of, it's maybe interim.
Interim
Well-
order granted by the order dated, stands extended till the next date of listing.
Yes, possible.
Worship, I beg to mention item 9.
9 is mentioned already, I think.
No.
9 is there.
9 is
Hmm?
there.
9 is still there.
So I wrongly ticked.
Lodge.
Made a matter, may fix for 26th of this month.
This one you are for the petitioner.
Yes.
Mr.
No, I'm appearing on behalf of HT Tara.
Learned Counsel appearing on behalf of, appearing for the petitioner side. Praise for fixing the matter on
26th of this.
26. 26 is a working day, right?
Yes.
On 26th of this month. Prayer is allowed, fixed on 26/11/2020.
Obliged.
Someone has joined. One sec.
Item number 37, unlisted motion matter.
Anticipatory bail. Yes, sir. Please go ahead.
This APS file in respect of the Sagale PS case number 28, 2025, which has been filed under 300-3183 and 3164 BNS. So before I proceed, Your Honor, may I please take a logic to the FIRs, which is in page number 14 of my petition.
14.
Yes, Your Lordship.
Okay.
Subject FIR against Sri Nandi Chada, incumbent BM, APRB, Sagali branch. Sri Milo Arun, former branch manager, Sri Neil Kanwar, former branch manager, and all staffs of Sagali branch and staff of APRB head office Naharlagan. For criminal conspiracy, cheating, breach of trust, misappropriation of deposit amount, theft from my MTL 51 AC number so and so, and my personal bank account number so and so maintained in the APRB Sagali branch. Sir, with due respect, I have the honor to lodge this complaint for necessary action. It is to inform that I am a landlord where Arunachal Pradesh Rural Bank Sagali branch is functioning since 1991. I am to inform you that I had taken a loan amount of rupees 1,73,000 for Maruti car loan bearing registration number AR013121 from Arunachal Pradesh Rural Bank Sagali branch during the year 2011. So I was informed by the then branch manager, Mr. Neil Kanwar, to open a passbook. So accordingly, I opened MTL 51 AC number so and so. I was advised to complete the monthly term loan within 36 months with effect from 18/9/2011 at rupees 4,850 as per the monthly terms. 1. I took Maruti car loan on dated 18 August 2011 on monthly term loan basis at 4850. Subsequently, I had completed the payment of the said loan amount within 21 months, which was supposed to complete within 36 months. The total payment of rupees 2,06,600 for 2,06,604 only was paid against the said Maruti car loan within 21 months. Yet the said loan MTL 51 was closed on dated 15/6/2013 after 1 year and 10 months of the payment of the said loan amount. After closing the said Maruti car loan MTL SC number so and so on dated 15/6/2013, the then bank manager Sri Milo Arun, the then PM APRB Sagali branch on dated 28/9/2022 directed rupees 6,354 only from a personal account number so and so transferred to some unknown account number so and so. Moreover, again on dated 14/11/2022, the then branch manager Sri Milo Arun directed rupees 50,000 from my same personal account number transferred to some unknown account number so and so. The directed was made without my knowledge and consent. Upon the inquiry about the unauthorized transaction, the former manager and his staff were refused to cooperate and disclosed the owner of the unknown account holder. I losses total rupees 56,354 from my personal account. After a gap of 10 years, I was again informed that I have left overdraft of rupees 92,500 against the said Maruti car loan. So, on dated 7/6/2023, I visited the bank and they informed me that I was required to pay 1,73,000 only, not rupees 92,500 to the bank against the said MTL 51 loan. As a layman, I was fully trusted them and made cash payment of rupees 1,73,000 to the incumbent branch manager Sri Nandi Chada in presence of the then branch manager Sri Milo Arun. After making the payment of rupees 1,73,972, the branch manager reflected the amount using a pencil on the demand draft page. After some time, I realized that the bank had duped my hard-earned money in the name of MTL 51 loans as mentioned below. A, the total amount paid to the bank from loan starting amount dated 18/9/2011 against the said Maruti loan is of 2,06,604, which I was supposed to pay 1,70,000. However, I end up paying rupees 33,000 only of more than the actual loan amount. B, on dated 28/9/2022, sum of rupees 6,354 only from personal account to unknown account number so and so. C, on dated 14/11/22, sum of rupees 50,000 from a personal account to unknown account number so and so. D, on dated 7/6/2023, sum of rupees 1,73,000 paid in cash in form of cash to the branch manager in the presence of the then bank manager Sri Milo Arun. Total point number 6 here. After closing the MTL 51 loan account on dated 15/6/2013 till now, was lost to rupees 2,63,930 only in the name of the MTL 51 Maruti car loan. It is pertinent to mention that Sri Nandi Chada, incumbent branch manager, Sri Milo Arun, former branch manager, bank staff of APRB Sagali branch, and general manager, senior general manager, Arunachal Pradesh Rural Bank Head Office Nahalagan, needs to be thoroughly investigated for cheating, misappropriation, breach of trust, and criminal conspiracy by misappropriation, creating my deposited amount without my knowledge and consent, despite clause of my said Maruti car loan on dated 15/6/2013, and then dupe my hard-earned deposited money from my personal account number so and so. Therefore, from the above facts and circumstances, you are requested to immediately book all the persons involved and arrest Sri Nandi Chada, Sri Milo Arun, Sri Nil Kanwar, and their staff of APRB Sagali branch, as well as a chairman, senior general manager, APRB Head Office Nahalagan, who involved in such heinous crime, and requested the authority to recover my deposit amount of interest for the interest of justice. So this is basically the FIR, Your Lordship. Now, the loan was taken in 2011, Your Lordship. And as per the allegation, in 2014, 6,000 was deducted, and in 2022. And again on 14/11/2022, 50,000 was deducted.
The loan was taken quite a few years back.
Yes, 2011.
So,
And he says that direction has, even the direction as alleged has taken only on 2022. So after a gap of so many years, he has filed this FIR.
Hmm.
That effort now he further alleges that now you lordship, the present applicant, he is the present branch manager.
Mhm.
So at the time of the taking loan, he was nowhere in that place because he was posted only on he was posted only on 14 April 2023.
Mhm.
Whereas all the allegations of the loan and the direction took place in 2011 and 2022.
Mhm.
If you lordship look at the page number 17, that is my transfer order. For it clearly says that I was posted on the date itself, 4 April 2023. Para page 17 here, Your Lordship.
He joined in 2023,
Yes,
April
yes,
2023.
yes, the applicant. So he has no involvement or no knowledge regarding the loan application or regarding the alleged
I see.
directions.
You received copy? Hmm. 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 Let him record his statement. That we share what he has to say from his side. And the transfer order, what he said, he's joined after this police override, so that may be true. You're Mr. Taja.
Petaja.
The Taja, learned counsel for the petition and also learned additional PP for representing the state. The petitioner invoking section 482 of the BNSS seeks anticipatory bail in connection with Sagali PS case number 28 of 2025 under section so and so full stop. The same arose out of FIR dated 30/10/2025 lodged by Tar Aya. The details have been mentioned in the said FIR. Sure. Preliminary, I see. The FIR is dated. 6/5. 5/5. FIR dated 5/5. The details, the informant has narrated the details of the facts which have given rise to the allegations. Full stop. In a nutshell, she had taken a car loan from Sangli branch of Arunachal Pradesh Rural Bank in 2011 itself. Full stop. The loan amount was rupees 1,73,000. So, however, subsequently, it is stated that she has repaid the said loan as per the schedule. However, different amounts were transferred from her account to one unknown account on several occasions, and in this way, total amount of rupees 33,604 was illegally realized from her. Full stop. It is stated in the FIR that the branch manager, former branch manager, bank staff, and other officials should be investigated for their role in the said matter. Full stop. The learned counsel submits that the petitioner is not at all involved in the alleged offences. Full stop. He also draws the attention of the court to Annexure 2, which is a transfer order dated 4/4/23, posting the petitioner Nani Chada at the Sangli branch upon being transferred from the Bhalukpung branch. Also heard learned additional call for the case diary from the concerned police station. However, in view of the facts, emerged circumstances from the materials and submissions, I deem it proper to give an opportunity to the petitioner to record his version of the events. Full stop. Accordingly, it is directed that in the event of his arrest in connection with this case, he shall be allowed to go on bail of rupees 25,000, one surety. Okay, less.
15,000.
Huh?
Kindly 15,000.
So 15,000 with one surety of the like amount to the satisfaction of the arresting authority and subject to the condition that he shall render cooperation to the investigation and shall appear before the IO, making himself available for examination. He shall not hamper or tamper the evidence. List the matter. 20.
Item number 38, unlisted matter for withdrawal.
Lordship,
Yeah.
I'm trying for withdrawal of this criminal petition, so I may be allowed to
Yes.
leave at the Lordship.
Learned Council criminal petition number 90 of 2025. This is the list.
No, this not.
I think submits that he has instructions to seek withdrawal of the criminal petition. Prayer is allowed. The instant criminal petition stands disposed of upon withdrawal.
With liberty, Lordship, I'll file a fresh lawsuit because so many new developments has come up, so I have to incorporate all those documents.
Then before that, you write, it is also submitted by the petitioner that he may be given liberty to file a fresh criminal petition in the context of several subsequent and new developments.
Yes, Lordship.
The prayer is allowed. That is the instant criminal petition stands disposed of, subject to the aforesaid liberty. Okay.
Deeply obliged.
Item number 5,
What was this matter earlier?
My lord. My lord, I'm
Yes, left-
appearing.
left
appear-
over. Oh.
My lord, I'm appearing for the victim here, my lord. She is being represented by a mother because then she was a minor and also at the time of filing of this appeal. My lord, I'm a survivor of a sexual offense and my lord, I have appealed against the judgment whereby the accused has been acquitted, my lord, of the offense. Judgment
Oh, I
dated
see.
6/12/2023 arising from the special court at Khonsa, my lord. My lord, in this case, the paper book has been, it was ordered for the paper book to be prepared. Same has been done and we have been served with the copy of the same, my lord. Matter is ripe for final hearing,
Anyway,
my lord.
you are Mr. Khera.
N. Khera, my lord.
There was some delay that has been condoned, right?
My lord, delay was condoned, appeal has been admitted and accordingly the ECR was called for and paper books were ordered to be placed.
It's come up for admission column strongly, I think.
Wrongly, my lord, order dated, my lord,
Yeah, please help
24
me with
to
that. No,
25.
must have been.
Says
20,
admit the
24.
appeal.
Yeah, that's true. So it's been,
My lord will find the impugned judgment in paper book, page 36, my lord.
plus statutory provision would not be 378(4), I think. It would be 372 proviso. I think. Appeal, like by the victim. Okay, yes, 378(4). Let us see, must be, I may be wrong also. Because victim appeal, one provision is 372 proviso, right? Doesn't matter, that doesn't matter. Let's be clear. I'll also be, maybe I may be wrong. 374. Appeal from convictions. No, this has been wrongly quoted. So, no, sorry. 374. 374 is pertaining to conviction. 378 is pertaining to acquittal. It's a not complaint. This was a GR case, right? This was a GR case.
My lord, it was the GR case, the POCSO special case, GR case. my lord.
Then the quoted section is wrong. And it will be, well, I'll correct it in this order. It will be no appeals are provision except as provided by law. Where the right to prevent appealing in order passed by executing the convict. Yes, 372 proviso. The provision will be 372 proviso. And Khera Learned Counsel for the appellant. The instant appeal has been filed by the victim invoking the provisions of. This was under CRPC only, or at the time BNSS had come.
My lord, CRPC, my lord. It was in
Under the
MIPC
provision,
case.
invoking the provisions of section 372 proviso of CRPC as it existed then. Assailing the judgment and order dated 6/12/2023 passed by the Learned Special Judge POCSO Khonsa Division, Tirap District in KSA/SC POCSO case number 4 of 22 within bracket arising out of Changlang PS case number 19 of 22 bracket close. You give a dash whereby the accused was acquitted. The accused who faced trial under section 354 capital A IPC RW red with section 10 of the POCSO Act, was acquitted. Full stop. The appeal has been admitted by the order dated 24/2/2025. So will you make the correction in this? Wrong quote has been made. This 378(4) only.
My lord, will correct it.
In the cause title, perhaps inadvertently, the statutory provision mentioned is section 378 subsection 4, though it should have been section 372 proviso CRPC. The appellant is at liberty to correct the same. You can do it before registry later on, right? Correction may be done for the registry.
Your Lordship, I'm for the respondent number 1.
Yes, for the accused.
Yes, for the
The accused.
we'd like to file our reply if so required.
My lord, paper book has been called for the question of reply.
So we will be given.
Criminal appeal is actually not, criminal appeal is acquittal, right? You
Yes.
can submit a.
Yes, that is true, but
My lord, as per standard practice, once the arguments are done, we can submit our note of argument.
You can submit written argument also.
Yes.
That would be taken into
Maybe-
consideration, your points. All the
last
points.
occasion, Your Lordship, I request to file written agreement only in respect of the IA, not in the main petition. So that was accordingly argued and disposed IA. But in the main case, we like to file a written reply. So kindly allow us to some more time, Your Lordship.
Mr. K. Taja Learned Counsel appears for prosecution is which respondents? 2, 3, 4. Oh. For the respondent number 1, who was the accused who had faced the trial? The respondent number 2. Okay, what about 5, 6, 7? Not necessary. They should we strike them off?
My lord,
Mhm.
my lord,
Because otherwise they will have to be served.
my lord,
Learned
5, 6, and
Hmm?
7 are very much a necessary party, my lord.
Okay, wait. Learned additional PP, madam. Represents respond number 2, 3, and 4. Full stop. 5 upon 5, who's appearing for 5 then? Okay, then we'll have to wait for the notice. We'll have to wait for the
My lord,
notice.
it has
Service
already been
report-
served. They have appeared, my lord. Earlier also in the IA also they have appeared. It has
In
been
IA,
served.
they never, no, they never appeared in IA. Yes.
They have appeared, my lord. Order will show to that effect, and they have already been served.
No, let me check, let me check.
My lord, they have been served.
Office note dated 10/11 says that, don't write. It says that service report has been received with regard to 5 and 6, but awaited for 7. But service report, okay, it is flagged. Let's cross check it because since they let them.
My lord,
5
5,
and
6, 7
6.
are same. They are the same institution, just 3 hierarchies we have given.
That's
And
true.
my lord, they become a necessary party for the primary reason that, my lord, the trial court has.
Okay, we'll keep them, no issues. I just thought, we'll not strike them off. They will remain. They'll remain, but therefore this service has to be there. 6.
My lord, in the interest of justice, before the next date, we will cause a dusty service upon respondent number 7.
Wait.
My lord.
Yeah, that's true. Upon perusing the case record, I find that service upon respond number 5 and 6 have been served. However, service report upon respond number 7 is still awaited as per office note dated 10/11/2025. You want to serve Dusty?
My
You
lord,
can.
we'll serve it dusty, my lord.
Have to be very fast. Okay, but since. That's true. That is true, but private person Dusty should be avoided in criminal, even if it is permissible. But since they are an authority, Assam Rifle, that is why I thought. Okay.
My lord, let us take both the steps. We will do it by registry and dusty will do both the steps. That balances it out, my lord. Any concern?
The petitioner shall take fresh steps upon respond number 7 and to be routed through the office of the public prosecutor.
No, my lord, respondent 7 would
consult
be,
is-
my lord, DSGI, my lord.
Yeah, it will go, definitely, it will come back. Okay, it will come back. Only through the prosecutor. Dusty is not necessary at this stage.
My lord,
Okay,
let
not
us, my lord, we may be routed through the office of the DSGI, my lord, since respondent number 5, 6, and 7 would be represented by the Deputy Solicitor General's
No,
office.
wait, this is the usual procedure we follow, isn't it? Yes, let it be like that only. The paper book is also ready. Full stop. After the completion of the aforesaid procedure, the matter can be posted for hearing, right? Don't worry, this won't take much time.
My lord, our
Actually, let me
only concern was, my lord, this victim, till the case is going on, she's under trauma. I don't have much words to describe, my lord, but then it takes a
That's
lot
true.
of courage for somebody to come for an appeal
Yeah,
against
definitely,
an
very
acquittal,
good.
my lord.
No, it's okay. He has every right to do so,
My lord.
He has every right to do so. Some
My lord,
interim compensation can also
why-
be considered for her during, the pendency and the provisions of 357A.
My lord.
If that is required for her rehabilitation, that has nothing to do with the accused who has been acquitted. But so this is the thing. So I'm again asking, madam. So he has some anxieties, it seems, about quickly completing the process. So should we allow Dusty also? It's not necessary according to you. Please guide me. Please take urgently. Mhm.
Section 2.
And this will be very easy
It's-
because
it's-
it's Assam
It
Rifles.
won't take much.
Don't worry, it will be done quickly. This process only, but it will be done quickly.
My lord,
I understand your concerns.
and my lord,
The way-
if I
yes.
may, my lord, the only reason why we are insisting on 5, 6, and 7 to be a necessary party is that, my lord, under the Assam Rifle Act, which is akin to the Army Act, my lord, section 125 and 126. Once there is a criminal case and the case has been charge sheeted, it is the duty of the trial court to intimate the commanding officer of the accused.
True,
If it is,
true.
if they will take it up as a court-martial proceeding, or they will allow the civil court to take up. Because the offense happened within the confinement of an Assam Rifle camp, my lord, inside their
Right, right.
jurisdiction. So the trial court, my lord, learned trial court, my lord, the trial court failed to abide by this particular provision and issue a notice upon the commanding officer of the accused, my lord.
True.
So that
There
is
are
also,
judgments also with regard to that.
Yes, my
There are
lord.
some judgments also.
There
Anyway,
are-
so don't worry, I without without being appraised of these factors, in detail,
my
I
lord.
thought initially that they will remain as part. We are not striking them off. And everything is ready, paper book is ready, TCR has been received,
Yes.
the TCR has also been received. So this process, we can
Only,
get it
only
done,
the process.
and then fix it. And when do you suggest me to fix the date?
After 2 weeks, Your Lord.
After 2 weeks. Okay, after 2 weeks.
My lord.
Madam, you just write, the Land Council appears to electronic mode.
Your
Okay.
Lordship, in meanwhile, I may be allowed to file reply if required.
Reply, they have already got chance of it.
No, not in
Yes.
in respect to the
Or
IA.
even otherwise, the court will be relying upon the.
The Learned Counsel for the informant, for the accused, submits that he may be given an opportunity to file a reply. You, within these 2 weeks, you file it.
Yeah.
Huh? It may be done so on or before the next day. Okay, this is sufficient. Be prepared. Otherwise, see, the criminal appeal, there's not much problem. It's not like civil or writ petition. You can always, you file a reply, whatever you want to say. And then at the time of argument, you can always address it. And if necessary, even find points wise or, concise written argument also. This is the matter of the 2 weeks.
Okay, Your Lordship.
If it does not come up, you make a mention.
Item number 10.
Yeah, so no problem. Item 10, criminal appeal. Any more unlisted man? No.
Item number 10.
TCR has been received. Oh, not TCR. Not TCR.
If my lord TCR has been received, then registrar may direct to prepare the
No,
paper form.
it's received copy of judgment of lower court.
And it's in the
Copy
court.
of judgment. Copy of it. She means the lower court record or?
My lord, it's reflected at TCR, my lord, in the cause list.
No, it's a come, that means. no,
Yes, madam.
That's one. Yes, just come. Come, yes, that's right. Here was the order dated 2/9/2025. Passed in this jail appeal. Full stop. Sum V. Darang has been appointed as
Legal aid counsel.
legal aid counsel. Has been appointed as legal aid counsel. She is not present today. The appeal has already been admitted. TCR has been received. Should we ask for preparation of
Yes.
paper book?
Yes.
The paper book may be prepared. Mr. Mr. Tabu,
Theatre, my
he has learned additional PP appears today for the state. So I need no other step, right? Any notice or anything to the other side? If you meet the learned council, legal aid council, please inform.
Yes, ma'am.
Uh, It's 326 matter.
326.
Informant not necessary, no? Not necessary.
My lord, in the most of the case, my lord, in light of this Jagdish,
That don't you, someone showed, no? That one.
yes, my lord, basing on that, my lord, participatory, considering the participatory right, usually the court issue notice to the victim, my lord. And victim include, it's a, now the victim definition is very clear, the kith and kin and the relative.
This judgment is,
My lord, Jagdish Singh versus,
Judge, Jagdish,
Singh versus Ashwin something, my lord,
Jagdish Singh, is that the victim has a
participatory
participatory
right, yes.
right in every stage. of
Yes,
the-
every, right from the
from bail to
investigation,
all the way.
yes, still culmination of the appeal and revision, my lord.
That makes sense.
So, yes, my lord, although, there are
It
many.
can help in the adjudication also sometimes.
Yes, absolutely, my lord. So although the implement is not required, my lord, there were several discussion and debate before this honorable court. The Deepak Nayak
And
case
also
is,
learning.
it has been settled so far as POCSO is concerned. But Jagdish Singh matter is confined to the general law. And in general law, it has been decided, it has been settled by the apex court recognizing the participatory right of the accused. If participatory right is been recognized by the court, then it is in fact our duty to my lord to implement it by way of issuing notice to the
You're very
victim.
right, actually, because otherwise, suppose the victim or the informant side simply wants to give some assistance to the public prosecutor,
Absolutely, yes.
rather than make some, substantial submissions on its on his own.
Yes, my lord.
But even then, he or she will come to know only when you are noticed.
Yes, my lord.
Right.
And your lordship, it has been also further held that they are
You're
not,
right, actually.
yes, auxiliary or, yeah, my lord, the accessory to the public prosecutor. They are independent in this stage, may not in the trial, but during the appeal
True,
as
true.
well as in.
Jagdish
bail.
Singh, that's, I'll need the citation. I think I have.
Yes, my lord, I will provide the
Yes,
citation. I
please
just-
do, huh? Thank you.
Yes.
So, what do we do? Since it's jail appeal.
My lord, my lord, jail appeal, since the record has been received,
Yeah.
after preparation of paper book also, your lordship, we can find out from the record but who is the victim in this case, my lord. Because we, in jail appeal, we usually get, my lord, the judgment copy only. And sometimes they do not file in the proper format also, my lord. So sometimes it's become difficult to find out the relative of the victim.
No, victim informant. Suppose victim and informant are different, then you notice
Victim.
both.
No, my lord,
Oh,
then
inform-
victim only, my lord.
Victim or informant.
Yes.
Actually, it should be both, and ideally.
Yes,
Wangna Kidney is the name.
Okay, okay, my lord.
The first para of this thing.
In Bormoti Pangin matter, my lord, that issue was settled. That
So you think it should be kept for a subsequent occasion when the records come?
my lord, that will be better if, my lord,
Records have already come, I think. Records have already come.
and my lord, the registry can do the needful by taking steps to the victim, my lord, if it has been reflected in the order, my lord.
In para 1 of the impugned judgment, the informant is stated to be one WANG NAK KITNY, comma, the younger brother of the victim. Full stop. Issue notice upon the informant and victim. He has been convicted under which section? The appellant has been convicted under section 326 IPC. Informant and victim both. Registry shall do the needful.
Yes. And my lord, the citation is 2022-9.
2022,
Yes, my lord. 9 SCC 321, my lord.
321.
The relevant paragraph is 22, 23, and 24, my lord.
Victimology is, way back when we were in law school, myself,
Yes,
or my teacher told me, he had such foresight.
yes, my lord.
I must say no more, that, in your times, he said, that this, the role of the victim will be increasingly.
Yes, my lord. In
Important.
fact, we get better assistance when they appear, my lord.
Victimology, you know, it's very good. It takes the criminal justice system forward.
Yes,
actually.
madam.
And in some ways, you know, and I cannot specify, tell you how exactly in specific details. But in some ways, the presence of the victim can also sometimes help the defense also,
Yes, madam.
rather than,
Yes.
normally you will think that if the informant, the victim
Both
appears,
sides,
it
madam.
will be very detrimental, no, not necessarily.
Yes.
If all the parties are before the court, it ultimately it helps the case,
Yes, madam.
which is about finding the truth
Yes, madam.
in a criminal case.
Yes, madam. Absolutely. Oblige, madam.
Matter number 11.
Criminal petition?
Yes, please, my lord, my lord. I was supposed to take instruction, my lord. I have got it, but then it's not adequate, my lord. So
Settlement was going on. What did you
No, no,
submit
my
in the
lord.
morning?
no, my lord. So I've instructed, I've informed the
It's not-
officials, my lord, to give me the full instructions.
I see. You are for the?
I'm for the state respondent.
Oh, I see. I see. What was the matter? Washing machines and all. Vigilance matter,
Yes, my lord.
extended. Double jeopardy principle, huh?
Yes.
Prosecuted again, he says. Anyway,
There was a specific
TT Anthony you're referring.
Yes,
Anyway,
query from the court whether this amount which has been alleged in this present petition, whether it comes under the earlier registered FIR.
ambit of
Yes, yes.
the earlier prosecution.
Yes, sure, sure. So the instruction which I have got is not adequate, my lord. So may I humbly pray, my lord, I may give him some more time, my lord, so that I can take fresh instructions, my lord.
Okay, let him take the instruction. It's quite an elaborate order is there.
Yes.
This Bodhi's, the earlier, use the last order heard so and so.
And
Yeah.
my lordship, interim order may continue.
Yeah, that, okay. So peruse the order dated 37/2025. Stop. The learned additional PP for the
Special PP.
special PP representing the vigilance,
Now it is ACB, my lord.
anti-corruption bureau.
My lord.
It should be like that only, actually. ACB, ACB, Arunachal Pradesh. Where to take instructions. But submits that he needs some more time for the same. The prayer is allowed. The interim order granted by the order dated 37/25 stands extended till the next date of listing. List the matter
3 weeks.
after 3 weeks.
Deeply obliged.
Matter number 12.
Lordship, this is a criminal petition for passing and setting aside of GR case number 96 of 2023, along with FIR and charge sheet.
Mhm.
Lordship, Lordship, may kindly come to page number 28. That's the FIR.
Page 28.
8.
Yeah, just a minute. I'm just checking the stays of the case. So just a minute. Caution. Okay, service is complete. Anyone has appeared for the
Not yet,
complainant? Not yet. Right. Now we shall see the FIR, right?
Yes, page
Okay.
number 20.
28.
Yes.
Mhm.
Where perusal can clarify a lot of stuff here. Mary. Lordship, I, Abhi Sabho, Proprietor A Enterprise Park from West Tamil District, Arunachal Pradesh, humbly approach you that regards to lodging an FIR against Chief. This is the petitioner. Chairman and MD Managing Director, JV Cement Limited, Guwahati, for fraud and cheating and not paying dues to me for rental of 4 vehicles provided on hire to the company. The details of the case are as given in the succeeding paragraph. So here, it was for non-payment of dues for the rental of the vehicle. This is the crux of the case is non-payment of dues. During October 2021, I was approached by Sri Darsan Jindal, husband of Srimati So, proprietor PPK Enterprise, village TP Bagpung, assist his wife in the business of PPK Enterprise with a proposal to provide 3 numbers of have a 10-wheeler dumpers on rent or lease to them for employing them with duty mining and network service private limited at village Mahizar, Nambu, PO, Longchung district, Janke Hills, Meghalaya for a period of 5 years as per the terms and conditions as given in the deed of agreement 21 November 2021. And the work order dated 18 October 2020 issued by the Mining and Network Service Private Limited to MS PTK Enterprise. Since at that time I had only one 10-wheeler dumper, I bought 3 more new 10 Ashok Leyland with 10-wheeler dumpers by taking loan from SBI Balco in December 2021 and conducted them in Meghalaya in first week of January 2022 to work with UD Mining and Network Service Private Limited, which is part of JUD Cement. Thereafter, Sri Prasan Jindal approached me to provide one more 10-wheeler dumper. Hence, I took out one Tata dumper, which was working independently on a contract and sent it to work with other dumpers in first week of January 2022. However, no payment was made to me either through PTK Enterprise or directly by UD Mining or JUD Cement for mobilization of the dumper or as advance payment as per the agreement with PTK Enterprise due to non-release of sum by JUD Cement during February to April 2022. Sri Kalsan General kept supporting JUD Cement for release of payment and finally JUD Cement gave a check to Sri Kalsan which bounced. The same will be confirmed on the following if required. Finally, one payment was released on 7 April 2022. So this is important. The payment was made. Thereafter, JUD Cement stopped responding to Mr. Kalsan Jindal. Hence, I approached JUD Cement Limited to give me a work order directly so that payments could be made to me without going through PPK Enterprise. This part is also important. The informant has approached the company of the petitioner and asked for work order. The same was agreed by JUD Cement and work order was issued to me. Copy of same etc. However, Mr. Adarsh Jhunjhunwala, CMP JUD Cement kept delaying payments on some pretext or other, and only partial payments were made to me, and that too when I stopped my vehicle from operation. Understanding the need of JUD Cement to keep the vehicle running in order to keep the plant operational, I kept cooperating with them, and in turn, Mr. Adarsh Jhunjhunwala kept shipping telling lies during court by sending false transaction receipts and took advantage of me being a simple tribal woman who was helpless and did not have any option to get my payments released. I even met others along with Sri Tatsan Jandas in January to July 2022, and he promised that all pending dues will be cleared in next 15 days. But that didn't happen since my liabilities kept mounting on account of paying EMI of the vehicles, regular servicing, replacement of tires, and the payment to the drivers and helpers. I had no option but to approach Sri Alexander Ladu, Honorable Minister for Animal Husbandry, Veterinary and Fisheries, Meghalaya government, and I met him twice when he called up Mr. Adarsh Jhunjhunwala to promise that all my dues will be cleared within next 15 days, but that was also a false commitment. Since my death and liability on payments due from JUD Cement, the tune of over rupees 85 lakhs will be made every month, I was left with no other option but unilaterally withdraw my vehicle on 31 March 2023 to avoid further loss and injury to my mental health and which not having heard of others thereafter I humbly approach you to kindly register a case against Mr. Others Senjuma COD for cheating forgery crime against women and reporting unbearable distress, trauma, financial loss to which I would like also request you to take action against Mr. Senjuma COD cement so that the dues pending from due to cement to me are released to me at the earliest.
So this is the gist of FI. Here, the main issue is non-payment of dues. And accordingly, the investigation was done and the accused was charge sheeted under section 406, 420, read with 138 of NI Act.
No, that's not tenable. That's, charge sheet cannot be filed under the NI Act. NI Act
Yes,
is
yes,
different.
that is there.
So I
That's wrong. In fact, it cannot be registered also under, it's non-cognizable. And secondly, it has to, you have to file a complaint case, but 420, yes,
420.
you can, that has to be seen whether elements are there.
Yes.
It is, so what is the, it is read today, we may have some constraints in disposing because there's a reference today on judge,
Your Lordship can take up this
former
matter tomorrow.
judge, right, died, no? So tomorrow,
Or maybe next week.
Because
Your
there is no stay, Lordship, it's been pending.
it will be, otherwise, you said it is served, no? He served,
It's served,
but he has not appeared.
they have now appeared.
16th October. She has not been,
Yes.
She has not.
Abhay Cycle. 16th October. Say about a month. So should we admit it?
Your Lordship can admit, if I may just suggest, Your Lordship,
Yeah,
in
yeah,
such
sure.
situations, what happen is when the notice is given to the private respondent, sometimes they don't appear and Your Honor can, in that case, appoint any of the legal aid counsel because amicus to assist the court in this matter, because otherwise the matter will be heard. Though the its service has been
You're very right. POXO, we are doing it regularly.
because if the respondent were not given notice and they were not made a party, that would have
That's
been a
different.
case.
So, and should we keep it at the admission stage or should we admit it?
Lordship,
Admission will take it to hearing, come in the hearing list.
yes. Your Lordship can admit this petition.
Because if it drags on,
Yes.
and since there's no entry, let it remain at admission stage only. Next week, let's fix it next week, right? Early next week, Tuesday maybe. Hard, additional fee. You're Mr. Gatz.
Yes.
Here's the order dated 17/9/25 and 21/10/2025, orders dated. The scanned TCR has been received and service upon the respond number 2/informant is also completed. Full stop. The learned additional PG submits that since none has appeared for the informant, perhaps the court can consider appointing an amicus. The learned counsel, can you suggest, because since I am new to the bar, so list is there, but still I do not know them. I'm
Amicus.
getting to know all of you.
In terms of amicus, Your Lordship can appoint N. Dangan, Your Lordship.
Okay, and Dangan, learned counsel is hereby appointed as amicus curiae to appear on behalf of the informant. So in the meantime, you can furnish her a copy. The petitioner shall furnish a copy to the learned amicus. Okay, in that case, do you think today is Tuesday? Today is Tuesday, right?
Tuesday, Your Lordship.
Next Tuesday? Okay,
Next
no,
Tuesday, Your Lordship.
you can file next. Fix on 18/11 at the admission column only. Let it remain the admission column, and then maybe we can try to dispose it of. Who raised the hand?
Lordship, Lordship, item number 28, Lordship. It's not
Just a
going to
minute, you also may mention one line, the endeavor would be made to dispose of the matter at the admission stage itself.
Lordship, I've mentioned item number 28, since it's not going to reach, Lordship. I only want to, I want to take first step on that.
Yeah, no problem. Item,
Item number
yeah, today it's 20,
28.
wait,
Uh,
CR
on respondent number 2.
revision, so orders. T. Gatso Learned Counsel for the petitioner submits that he would like to take fresh steps upon the sole respondent.
Respondent number 2.
Respond number 2. One is,
Or rest all completed, only respondent.
Respond number
is
2.
pending.
it is submitted that the service is complete upon the remaining, how many respondents are there? Will you be in a position to say? If you have the file, otherwise leave it, upon the remaining respondents. We'll see it next day.
Yes.
Remaining respondents, release the matter, prayer is allowed, release the matter,
First step along with justice service as well.
fresh steps along with dusty service, release the matter after 3 weeks, 4 weeks, 4 weeks,
3 weeks.
3 weeks.
Also, Lordship, item number 36, Lordship.
That is unlikely to reach.
Yes, kindly it may be listed tomorrow, Lordship.
My lord,
Since-
kindly, my lord. Tomorrow, if possible, my lord.
FA1. We'll not fix it day after tomorrow. Either it has to be tomorrow or next.
Tomorrow, my lord.
It's been pending for quite some time.
Is it? What is the matter?
My lord, it's a succession appeal,
Seen
my
it, I
lord.
think. Succession, yes, I had seen. I think. Okay. Some distribution.
Yes, my lord.
no? I've just glanced.
My lord, it's
Okay.
quite a simple issue, my lord. Only we're confining ourselves to only the first issue in this appeal, my lord.
Who's entitled and what is the share?
Yes, my lord, my lord.
Natural succession, Indian, normal succession, it applies in Arunachal Pradesh.
Yes, my lord.
It applies, right? The matter, 36 matters adjourned, list tomorrow. List on the 12, 11. Oh, here.
My lord, can it be taken up at 2, my lord? 2.
Let it come. We'll see tomorrow. Tomorrow you can always mention, we can have that flexibility tomorrow.
So like, my-
Item number 13.
Item number 13. I have to, we have to complete the page. 30%. That will complete. Yes, tell me.
My lord, this is a joint criminal petition filed by the informant victim and the accused, my lord. My lord, here the informant victim was the girlfriend and the accused, that is petitioner number 2, was the boyfriend. And a family member of the girlfriend, that is petitioner number was against the relationship. So the girlfriend, that is petitioner number 1, wanted to break up the relationship. So to pacify the girlfriend to continue the relationship, this accused had taken the informant victim in her own car from Alo to Namsai. And in the same evening, they returned to Alo and stayed together in the house of their in-laws, my lord. And on the next day, when this petitioner number 1 returned to her home, the family member pressurized her to lodge an FIR against the accused, that is petitioner number 2, ma'am. So then this FIR was registered, my lord. FIR is my lord, the FIR is at page number 20. My lord, may come. It's page number 20, and type out copy is at page number 21. My lord.
Yes.
Here, my lord, I am reading the content of the FIR. That with most humble and utmost respect, I, Miss Karyum Bagra, hereby state that on 5/5/2024, around 8 a.m., Mr. Bamuate, who was my boyfriend, forcefully took me in the car and took me to Tinsukia without my consent or approval. He snatched my phone and didn't let me contact my parents as per his not normal behavior. I intend to have no more connection with him. I hereby request you to kindly get my essential cell phone and my card to me. I intend on not having connection with him regardless of police warning he tortured me mentally. This is the FIR, my lord. And
She's, what is her name? Bamma Karyum Agra, okay.
Karyum,
And this
accused is Bamawat, my lord.
Bamma and informant is Karyum Bagra,
Yes, sir.
the girl herself,
Yes, my lord.
girl herself.
Yes. Then after the case was registered,
Hmm.
this girlfriend and a boyfriend, this petitioner, were convinced, they convinced their parents, and my lord, they got married.
They got
Now,
married.
yeah, they got married 1 year ago, and recently in the month of October also, my lord, they have been blessed with a baby daughter, baby girl. So they have filed this joint petition to quash the FIR and the subsequent charge sheet, my lord. My lord, here the case registered in this case is 379B IPC, my lord. My lord, this 379B is a state amendment of Haryana, my lord.
Oh, that's what I've never come across.
Yes. So Alo police has registered a case under.
No, I may not know some.
Yes.
Yeah, I may not know also.
Yeah.
So I may have missed something, but it
And then my lord.
looks
the second-
unfamiliar to
Yes.
us.
And my lord.
Haryana amendment.
Yes. And even if it is 379, my lord, this is compoundable case, compoundable section.
No,
And
366 won't be compoundable.
Yes, regarding 379. And my lord, regarding 506, also non-cognizable but compoundable, my lord. And regarding 366, my lord, of Indian Penal Code, the 366 of Indian Penal Code is related to the offense, my lord, where a person forcefully takes a woman so that she can be married with any third party, or she can be subject to sexual abuse by other party. So here, my lord, the fact of the case and the ingredients of 366 are different, my lord. Here, 366 totally do not take, my lord. So, my lord, this, my lord, may come to page number. Page number 86, my lord. This is the amicable settlement, my lord. Now, my lord, this informant victim and the accused has amicably settled the matter. They are married since the last 1 year, and they are living happily, my lord.
This marriage and birth of a child must have been mentioned in the petition, right?
Yes, my lord.
Can you help me with that?
Yes.
That will be reflected in the order.
My lord, may I please come to case 83? 83, the mother and child protection card, my lord, issued by the hospital. During the pendency of this joint petition, my lord, this baby was delivered.
No, any statement in the petition?
Petition, yes, my lord. My lord, may come to page number 11, this paragraph 17, my lord.
Para 11.
Page number 11, para 17. Page 11, para 17, and
Anyway. We have time constraint. I wanted to take up the two bail matters.
Okay, man.
So what should we do? Should I reserve it and then pass the order later?
Yes.
So your submissions are remain to be.
Yes, my lord,
You have completed or you have more submissions to make?
I complete.
This
Yes, your lordship, since they now they are husband, wife, and they have clearly stated they were boyfriend and girlfriend earlier also. And now your lordship,
from this medical document, it can be presumed that they were married because there is no any marriage certificate and all. It's just mere an apartment. But so far as the document is concerned, it can be presumed that they were married.
Which document?
My lord, this mother, my lord, may kindly come to page number 80.
Father's name Romo NT.
Yes,
84.
84, my lord. Here is written mother name Karyum
No,
Babra.
his statement on affidavit is
Yes, yes,
also
father's name also.
has to be, you know,
Yes, my lord.
there's no reason not to release that one. So, since this will, let me do the bail, so I'll reserve it then.
Yes, sir. Yeah.
Ma'am, heard arguments, reserve the map, reserve for the, I'll pass it, I'll write the order to them only,
Okay, obliged.
because we have to rise at 350.
Yes, ma'am. Deeply obliged.
TCR has been received, it seems. Record has been received.
Yes, yes. Record receipt, my lord.
Item number 14.
Like this, Lordship. My lord, in this matter, if there's positive that time, my lord, so I wouldn't be delaying much. My lord, make a directly come to the my lord, seizure memo, my lord. This is the crux of my argument, my lord.
21B, right? Case diary has been received?
My lord, the issue is case diary, earlier it was pending, now it has been culminated into charge sheet, my lord.
Yes, charge sheet.
During the pendency of this application, my lord.
My lord, may kindly come to the page 24, type copy, my lord.
Right. Right.
Yes. My lord, the particulars seized, my lord. 7 number soap cases containing oranges color powder such and such. My lord, these are the alleged substance collected, my lord. If we calculate all of them, my lord, it comes around 82.47 grams. First, number one, my lord. In numbers, second, my lordship will find 100 vials containing oranges colored powder weighing 138.37 grams, including weight of vials and plastic weight 3.2 grams, marked as exhibit. 3 also, my lord, 100 vials containing oranges colored powder weighing 137.5 exhibit is as 1, including weight of vials and plastic weight 3.98 grams. 7 and 4, 70 vials containing oranges colored powder suspected heroin weighing 9.749 grams, including weight of vials and plastic bag weight 3.5 grams. Rest, my lord, those are not substance, my lord. And number 7 only, my lord. Number 7, 10 strips containing 10 tablets of Nitcor 10 Nitrojapan tablets, IP 10 milligrams, and all that, my lord.
The other stuff is suspected heroin.
Yes, ma'am. Now, my lord,
Which
lordship
might
will-
be some kind of psychotropic substance.
Yes, ma'am.
And-
Now, your lordship will direct come to the order passed by the learned, a special code, my lord. This is page 29, my lord. How the bail has been rejected, my lord.
Just a minute, the section which has been given is
21B,
21B, right?
that's the contention, my lord. This application was filed for default bail, my lord. And it was rejected.
I do not know what would be the bracket, what would be the category of this nitrazepam tablets, 10 mg, 10 mg.
Now, lordship
Yeah,
will,
okay, 10 mg.
yes.
Nitrazepam.
Now, lordship, the,
Okay, let us on the order. right?
yes, my lord. Now, let's,
I'm on the order.
yes, my lord.
Page 25,
29, my lord.
29,
Yes.
detail order.
Lordship will directly come to my lord. Others or do description grams, my lord. Para 3, my lord.
Paratree, yes.
I've also, lordship got, I have also heard submission made by learned SPP. It is submitted, though there is no segregation of contraband substance from vial, but it comes with meaning of commercial quantity contraband substance and offense under section 21C of NDPS is restricted against the accused person. It is further submitted by learned SPP that accused Jiten Vishwas is habitual drug peddler and he has about 5 cases pending involving possession supply of drug. It is submitted the accused person may not be released on bail as offense for possessing commercial quantity contraband substances attracted against him. My lord, may kindly appreciate this is a bail, my lord. Bail application for default because the allegation against the present accused person is under 21B only, my lord.
Hmm.
In case of 21B, the default bail, he should have got within 60 days. Now, how the trial court?
This was the order disposing of the application for
Yeah,
default bail.
Yes, man. Now, Lordship Parapur, I have carefully perused the case records and seen that initially one Tanya Tatar was apprehended with contraband substance and he disclosed that he purchased the contraband substance from accused Jitin Viswas. Accordingly, police team raided residence of Jitin Viswasan, recovered several soap cases and contraband substance measuring 82.4 grams and 270 vials of contraband substance measuring 374 grams, including vials, 12 strips of nitrogen tablets containing 10 tablets of each strip. With 332 numbers of empty vials, it reveals the accused person was in possession of commercial quantity of contraband substance and he is a drug peddler. Though the present case is registered under Section 21B of NDPS Act, however, an offence under Section 21C and the PS attracted against the Jitin Viswas, besides there have 5 more cases involving possession of supply contraband substance pending against the accused Jitin Viswas. There is no doubt that he is habitual drug peddler and the present case cannot be considered lenient. Besides, there is a rider under Section 31A of NDPS Act while granting bail to accused person and commission of offence involving commercial quantity. As only ground represent bail application under Section 187 BNS on the default ground, the accused persons have completed more than 60 days in custody during the investigation of the case. Same cannot be considered. Section 36A 4 provides that when an offence involving commercial quantity, contraband substance is committed, then the mandatory period will be considered 180 days. In view above, it is observed that the accused person named Jitin Viswas is not eligible for default bail. When the investigation agency itself says the quantity is below commercial, because the substance were measured with the container and plastics. In case of other bail application, my lord, this
is heroin is 5 grams, 250 grams. Below 5 grams, small quantity. 250 grams is above 250 grams.
Yes,
is commercial quantity.
So,
But nitrozepam, I'm not sure. You have to check up. Anyway,
but how the trial court can alter the sections in the bail application?
So you make your submissions.
Yes, my lord. My lord, they have not assailed that order, first of all. They have to assail that order. The order passed by the learned special court, my lord. They have not assailed that order, first of all. And second,
it's a bail order, so they have come here, concurrent jurisdiction.
yes, my lord, absolutely, my lord. Concurrent jurisdiction is there. But once they are seeking bail on default, and if there is a wrong finding of the learned special court, then they have to assail that order, my lord. Now, my lord, the problem here is the charge sheet has already been filed. And in the meantime, they have not make any prayer before this court for default bail. They have not assailed that order. My lord, may kindly see the course title, my lord. This is then regular bail application, my lord. Your lordship will kindly page number 1. An application under section 483, that is for regular bail, under 2023 BNSS, praying for grant of bail accused person. The second part is the Bandardua police station case number so and so, arising out of past information report so and so. The order is not assailed. And the prayer portion also, my lord. Prayer, page number 12. In the premises aforesaid, it is humbly prayed that your honor may be pleased to admit the application here, the parties, and after hearing the same may be pleased to enlarge the accused person on bail, connection with so and so, with the term and condition as so and so. Now, my lord, the difficulty here is, my lord, even if the finding of the learned special court is wrong, how this court will adjudicate this matter where that is not a ground for your lordship challenging. I am not saying that order is correct, my lord. Assuming that order is wrong, my lord, it's always open.
Even if it is wrong, now since charge sheet has been already submitted.
Yes, my lord.
So we cannot give, we may not be able to give default bail.
Yes, now it's extinguished, my lord.
Considered as regular.
No, madam, can you
I may be wrong, you correct me.
appreciate that, madam? Once under default bail, a person has to, after when the time comes, he has to simply be ready to give bail bond. That's the law, madam.
Yeah, though in a sense, actually, yes.
Yes, my lord, I will, subject to correction, my lord. Yes,
Right.
if they challenge that order, then that will be continue, my lord. Because they raised this issue before the Lanage Special Court, which has been rejected, maybe on wrong finding or right finding. That is not the subject matter before this court, my lord.
Also, so, if leaving aside, independently also, if the court comes to this finding, that
Yes,
it's
madam.
actually the quantity involved, quantity is very important in it.
Yes, absolutely, my lord.
Right, so independently of the trial court's order, if this court comes to a finding that the quantity was commercial, intermediate
In
quantity,
intermediate quantity.
then, and this is an admitted position that at that time, the charge sheet had not been filed.
Yes, my lord.
So he had become entitled to default.
Yes, my lord, absolutely correct, my lord. I am not saying, my lord, it's wrong, my lord. What I am submitting is, but not in this bail application, that order has to be assailed, my lord. Because the finding has to be given on that order, my lord. Because the question there is whether the 21C finding of the special court was correct or not. That has to be looked into. If this court find that that finding was wrong, then they are entitled for the default bail.
That is, in a normal case, that is
Yes,
true.
my lord.
But in a bail petition, since you cannot, a bail petition, as you know, a bail order is not revisable.
Yes,
488
my lord, absolutely.
488
It's an interlocutory order, my
It's
lord.
an interlocutory order. It is not revisable. And moreover, we have this concurrent jurisdiction. Therefore, if a perverse bail order is passed, it can still be challenged by prosecution
Yes,
or
absolutely.
someone,
Yes,
under
absolutely.
482.
Yes, my
These
lord.
laws are there.
Yes, my lord.
But I'm saying, my point is that suppose this court independently comes to a finding that he was entitled to default bail at that time. So
Yes,
don't
my
you
lord.
think this court will be within its powers to grant bail?
Yes, absolutely. But your lordship has to give a finding that from that day, it is still continuing because the right, they have to avail that right. Once the right occur, they have to avail it and it will be continue. Even in the meantime, even if charge sheet file, it will continue, my lord. That is the law, my lord.
Indirectly, it will, your point is that if that is done, indirectly, it will amount to saying that this order is wrong, though it has not been challenged.
Yes, absolutely, my lord.
So anyway, let us keep it for tomorrow.
Yes, my lord.
Part heart.
Okay. Yes.
Part heart. What is the AB? Keep it for tomorrow. AB, keep it for tomorrow.
Yes.
Keep it for tomorrow. We can keep it at
Yes,
the
yes.
top of the list. We'll hear it in the morning only. Right? Should we keep it in the top of the list? And normally it will come. Normally,
Normally it will come, my lord. No, it
normally it will come. Because see, I'll not be here after this week. So part heart, we have to be careful. We'll not keep it as part heart.
Not
I'm
further,
here
my lord. Let it be listed tomorrow. If matter
Normal
comes,
course.
yes, yes.
Normal course.
Yes,
Let it not be part heart.
Yes, my lord.
My lord, sorry, sir, my lord.
There's this thing, there's a interesting thing. I have not come across any case laws on that point, If there must be this, that the language which is used in the 167,
Yes, my lord.
sorry,
187.
section 37,
Yes.
37, the language that if a person is accused of offense under 1927A,
In commercial quantity.
accused of, suppose take an example that the IO has given intermediate quantity
Yes,
section.
ma'am.
Take
Yes.
Ganja,
Yes,
easy
ma'am.
example.
Yes, madam.
20B he has given,
Yes,
suppose,
yes,
that's intermediate quantity.
Yes.
But that suppose by mistake he has given, but the Caesar list clearly indicates 25 kgs of Ganja,
Yes, madam.
which is commercial quantity.
Yes, madam.
So shall we go by the literal, the section given or by the substance?
My lord,
Is there any case law? I have not found it.
yes, my lord, the
I have not found.
settled
There
law,
must be.
so, my lord, so far as the settled law is concerned, throughout the investigation authority has a right and they are master of investigation.
Right.
They can put any section, my lord,
True.
till
but
the filing
thing-
of the charge.
No, if it is prima facie,
Yes, court can give prima facie view.
if it is if it is on the face of it, if it is wrong,
Yes,
Caesar list mentions 25 kg
yes,
Ganja.
my lord.
But the iOS, everyone is human being.
Yes.
Mistakes can be made. 25B, don't you think we'll have to go by the substance?
Yes,
But
madam.
in criminal
Absolutely,
law,
my lord.
so the beneficial interpretation is given to the defense.
Yes, absolutely. But my lord, the thing here is the court has to give the reasonable prima facie finding, may not be in the section.
No, sorry, I'm wrong. Beneficial intervention is given to the accused
Yes,
in
madam.
many situations.
Yes.
In this case, it will be against the accused.
Yes,
But
madam.
suppose the prosecution, don't you think it should be interpreted as commercial quantity in that case?
Yes, my lord, one more aspect is here. Here the biles are also included, my lord. The bile where it has been kept, my lord.
Usually that way it is excluded, but.
Yes, my lord. In neutral, if it is neutral substance, then it has to be
Neutral
included.
substance,
Yes,
no,
but
that is included.
yes, but if it is
But if it's vial
Yes.
is like a
while is my
cover.
lord, it's a cover, my lord. It's a
Cover.
container, my lord.
Container has to be
And sometime in towel, sometime
Why
in
it has
my
to
lord.
be excluded? Why it has to be excluded is that because this NDPS Act is very stringent and very sensitive to quantity.
Yes, absolutely, my lord.
If it is commercial quantity, I cannot
Yes,
get
madam.
bail. So that proper substance, mutual substance, of course, that's a different law.
Yes, my lord.
That is a decision which says that now it has overruled earlier position.
Yes,
that,
madam.
it has to be mixed, neutral substance has to be
Excluded, included, my lord.
Why it has to be included? That the judgment which gave that.
Hira
thing,
Singh, madam.
Hari Singh.
Hira Singh,
Hira Singh.
Yes, madam.
So thank you. So that is explained there's one paragraph, right? Nicely it has been.
Yes, my lord.
Anyway, we'll come to that later. Let this be tomorrow and AB also tomorrow.
Okay.
Other matters, any
My
other
lord,
matter you
I
mentioned?
beg to mention item number 30, my lord. It's on joint petition and mutual settlement, my lord. Can this matter be taken up tomorrow, my lord? Item number 30, my lord.
Okay, list it. We'll try.
My lord.
Your Lordship, may I, Your Lordship? Your Lordship, I beg to mention item number 25, Your Lordship. It's a criminal revision petition, Your Lordship. It may be listed tomorrow, Your Lordship.
No, then next week. Against conviction.
No, Your Lordship, challenging the impugned judgment order passed by the Session Court and the CJM, Your Honor.
Okay, that's one. Criminal appeal was dismissed, right?
Okay.
Against conviction, that means. Can it
Your-
be
No,
not against conviction?
NI, Your Honor.
Oh, NI.
Yes, Your Honor.
But I can fix it, but I don't know whether it will be possible to fix it.
Your Lordship.
May I, Lordship? Lordship, item number 26.
26, yeah. Criminal revision.
Yes, that item may be list after 3 weeks.
Paucity of time, list after 3 weeks.
Interim order is there.
Interim order shall stand extended till next date of listing.
May I please, my lord.
My lord.
My lord, the AB matter, my lord,
Mhm.
it was listed on 4th, my lord.
Mhm.
So I've sought for the CD, my lord. CD is, I've got the CD, my lord. But my lord, may record only one thing, my lord. I am
AB means 15, item 15.
15, yeah, my lord.
Okay.
On the last occasion also, my lord, I did not find the petitioner in the court.
Okay, next, tomorrow we'll take up.
Today also,
We'll dispose it of,
the petitioner is also not here.
abandon it.
The question here is that, my lord, this matter was taken up in the vacation bench, my lord. So I was absent at that point of time. So the interim was granted, my lord. After the interim,
They
have come-
disappeared. That's not fair.
That's
So what do you do? Should we put it at the top of the list?
not necessarily, it
Normal
may be
course.
normal course. And my lord, still now, after they have got the interim, my lord, still now they have not served a copy to me.
No, that's conduct
So-
is bad. If item number 15, madam, you write none appears. The applicant but no, could not be taken up due to paucity of time. CD received
My lord.
tomorrow.
It can be on the top of the list as well, my lord. In the top of the list, my lord.
This is the matter. Interim bill shall continue till the next day. The matter may be listed in the then Selby, how do we say it? Put in the top of the list.
Might be after the motion, after motion, my lord, it can be taken up.
Put top of the list after the motion matters.
Yes.
May I, Your
Obliged,
Lordship?
my lord. Deeply obliged.
Lordship, item number 33 and 34. These are connected criminal appeal, Jan appeal.
Okay, Jeremy.
So may I pray that this matter may be fixed on 24th of this month?
Okay. Paucity of
It's a-
time, list on 24.
Lordship, obliged.
Anything else? Kindly,
My lord.
because I will get late for that reference.
My lord, item number 32, this is for only the permission to withdraw the deposited amount.
Okay.
So that may be allowed, my lord.
No, now I have to see the file, right? I don't know.
So on 13, it may be fixed for 31 and 32.
Monday, 17.
17, my lord, I have some cases. So 13, there is a case fixed, my lord. 13.
31, 32, right?
My lord, I mentioned item number 21 for the admission hearing.
Mhm.
TCR has already arrived.
Mhm.
Kindly give me 3 weeks for the admissions hearing.
As TCR has been received, let the matter up to 3 weeks. Can I rise? Otherwise I'll get late.